Item number 1 and 2.
For reasons mentioned in the judgment, both these intestate cases are dismissed.
May I please your Lordship? Lordship, I beg to mention for listing of an anticipatory bail application. It was filed on 11th of July. Lordship, tomorrow,
What is the matter?
PC Act.
Okay. Okay.
Lordship.
Regarding item number 22, I am appearing for the respondents. The petitioner side is also there. So there is an outstation counsel who is appearing, and on the last date, the date was given as 18/7. In fact, CIS also shows it as 18/7. But it got listed today, my lord. May I pray that it may be taken up on 18/7, my lord?
Okay. Heard Mr. S. Nawaz, learned counsel for respondent number 2. Also heard Mr. D. Day, learned counsel for the petitioner. It is submitted at bar that on the last date, this case was fixed on 18/7. However, it has been listed today. And as there is an outstation lawyer appearing for whom?
Respondent number 2, my lord.
Respondent number 2. There is some difficulty on his part to appear on. And therefore, it is prayed by both the councils that this matter may be listed on 18/7. The prayer is allowed. Let this matter be listed on 18/7.
Deeply, my lord.
The interim order may be
The
continued.
interim order shall continue till next day.
Another prayer for listing of a BA, my lord, NDPS case. It was last listed on April, my lord, in April, and it was supposed to come up after 2 weeks, but it has not been listed. Any day this week, my lord.
Thursday.
May I please proceed? I am praying for listing of a bail application, which was supposed to list on 17/6.
What is the matter?
NDPS. Charged matter. Scan copy was called for, but till today the matter didn't come up.
When do you want?
Tomorrow, day after tomorrow, my lord.
Day after tomorrow.
Day after tomorrow. Always.
May I please your lordship? Lordship, I beg to mention a bail application. On previous date, that is on 18th June, it was ordered to be listed on.
What is the
18th
matter?
July, NDPS matter, your lordship. On 18th July, your lordship, but CIS incorrectly showed it as 15th July, your lordship. May be listed on 18th as per the previous order, your lordship.
Okay. 18.
Much appreciated.
Please, your lordship. Lordship, I beg to mention for the listing of a bail application. It was last listed on 21st of May. It was supposed to be listed after a week. It has not been listed yet.
When do you want?
Lordship, tomorrow.
NDPS matter.
Yes.
Day after tomorrow.
Lordship, then.
Tomorrow there will be likelihood that reference will be there. We will have less time.
Lordship, then Friday. Let it be on Friday.
Okay, on Friday.
My lord, I beg to mention item number 51, my lord. It's a quashing petition, my lord, and a case diary was directly to be called by this honorable court. As I understand, my lord, the case diary has not yet come, my lord.
Heard Mr. What is your name?
M. Sharma, my lord.
Heard Mr. M. Sharma, learned counsel for the
Petitions, my lord.
petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed again on
24th.
24th of
My
July.
lord, if a date next month may be convenient, subject to your lordship's convenience. Any date next month, my lord.
On 5th of August.
Grateful, my lord. The interim to conclude, my lord.
The interim order shall continue till next day.
May I please, your lordship? I beg to mention for listing of regular bail, lordship.
What is the matter?
NDPS matter, lordship, last listing of 30 June, lordship.
When do you want?
Tomorrow, lordship.
Day after tomorrow.
For withdrawal, item number 52 from supplementary list.
May I please your Lordship? I am appearing on behalf of Mr. I.S. Lashkar. On instruction of the petitioner, I am to withdraw this petition.
What is your name?
A.E. Khan.
A.
E. Khan.
Heard Ms. A. Khan appearing on behalf of Mr. I.H. Laskar, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Item 53.
Same order.
Revisionist motion again, item 3.
Met please, your lordship, charge sheeted matter, lordship, commercial quantity.
Whether scan copy is there,
Motion,
what is the ground?
47 and 40 violation is there.
Heard, Mr. What is your name?
Hussain.
Heard, Mr. S. Hussain, learned counsel for the petitioner. Also heard, Mr. K.K. Parashar, learned additional public prosecutor. Let the scanned copy of the case diary of which case?
So special case number 34 of 2024 arising out of Dhubri police station case number 221 of 2020.
Arising out of
Dhubri police station case number 221 of 2020.
case diary of Dhubri PS case number 221 of 25 B. Call for registry to take steps for requisitioning this scan copy. Let this matter be listed again on 6th of August,
221 of the 24.
221 of 24. Let this matter be listed on 6th of August.
Further may be given.
No.
Item 4.
Same ground, lordship.
Same order. Case number are different.
Different, lordship.
Dhubri P, which? What is the police station case number?
221 of 24.
Police station case number?
Sorry, lordship. Earlier one actually, lordship. Earlier one would be Tapul police station case number 110 of 24. And the present item is Dhubri police station case number 221 of 24.
God case to change for you. Same date.
Item 5.
Met please, your lordship. Lordship, Khati PS, case number 18 of 25, your lordship, and this is the commercial quantity. Case diary may be called for.
Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Let the case diary be called for. Let this case be listed again on
24, Lord.
24/7.
Much of that.
Item 6.
7.
7.
The mark of 24.
Question 483 application, lordship. The petitioner was arrested on 17/6/22, lordship. Today is 29 days, lordship. The FR in page number 14, lordship.
Where is the rejection order?
I have not annexed it.
Annex it.
Rejection order is not here, lordship.
It has been rejected by some court earlier.
Yes, lordship, that is.
You have to annex that order.
This is SDCM.
Heard, Mr. What is your name?
Yes, sir, Islam, lordship.
Heard Mr. S.R. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Das. Learned counsel for the petitioner has prayed for allowing the petitioner to file an additional affidavit to bring on record the rejection order of the trial court. The prayer is allowed. Let this matter be listed again on when?
Lordship, may I, Lordship, taking intelligence, Lordship, need this case, Lordship, whatever, suppose the accused case is fixed tomorrow, Lordship. So
When will you file rejection order?
today, Lordship itself, Lordship, because tomorrow co-accused case is fixed, Lordship, that is BA 204
Let this case be listed again
tomorrow, Lordship.
tomorrow.
Along with BA number 2044 of the 2025.
Not along with. Tomorrow, that is 16/7. In the meanwhile, the petitioner may file the additional affidavit.
Obliged.
Item 7.
Where please? The prisoner before lordship, my lord, he was in custody in connection of a NIA case for the last 5 years, my lord. He was arrested in that case, my lord, your lord, the home plus case, my lord. Though he has been named as a member of the unlawful officer, but he was not there, my lord. But anyway, my lord, he was arrested on that your lordship will find the order itself, that is bail order, my lord, that
Now, this bail application is with regard to which case?
now, no, it is on 9/6/25, I was granted bail, my lord. Immediately on the date when I was released from the jail, my lord, they have taken me custody in a case registered under section 120, section 18 and explosive substances, where I was not named in the FIR. That is of 1920, year of 2024, my lord. The law is more or less settled, my lord. Whenever a person is in custody, my lord, it is the duty of the prosecution agency to inform all the cases pending against him. In fact, yeah, I like to rely upon decision of there is Farooq Abdullah's case, Rejection, my lord, in this connection, my lord. Your lordship may kindly.
Yes. We'll see the case diary.
Understand, but fact remains that the arrest is illegal. Cannot arrest him. Because it's a case of 24, where I, for last 6 years, I've been in custody. They could have very much interrogated me. The police agency, the investigators knew well that I was in custody, my lord. They never interrogated me, my lord. Immediately I was released.
No, when police came to know that you are involved in the second case, when it came to knowledge of the police,
Only your question, they said that
because you were not named in the FIR.
but in the forwarded report, they said in the jail, I had made a conspiracy. If the jail, I have made a conspiracy with another accused.
We'll call for the case diary.
I understand, but you'll also kindly see that. This is it's a question of violation of Article 21, my lord. My
Yes.
rights, my
No,
lord.
suppose police came to know.
You'll also kindly see the forwarding report. Forwarding report will make it clear, my lord. So the way I was arrested, my lord. That you'll also will find at page 47, my lord. Relevant portion I'm coming to it, my lord. That page 48, my lord. During investigation, sufficient evidence was found against the accused, so and so. Sanmoy Loika so and so was previously arrested and forwarded in connection with RC case number so and so, so and so. During investigation in state case, it is found while the key mastermind Dunmoni Bora was in the process of raising a new armed extremist in the name of Revolutionary Front of Greater Assam. He was in touch with Alpha leader Chinmoy Lokor, who was lost in central jail. Chinmoy Lokor and Vijay conspired in Dunmoni furtherance of state conspiracy. They informed Dunmon Bora that 2 crores of cash were collected, were concealed in Nagali forest so and so. As per instruction, Dunmoni Bora had launched a sun operation in the forest and in the August 2024, man. And Chinmoy and Vijay were planning to use these 2 crores to produce so and so for using their alpha contact. Chinmoy and Vijay were providing outside support to RP and planning to join after getting out of the central jail. Vijay Junmon laws in the center, they maintain a close liaison with Junmon Bora, either through physical visit of Junmon Bora to central jail or SMS and phone call. This was Vijay Ahom and Chinmoy Lokor were clear about the RFGA and giving it identity after release on bail. So, your lordship, they know it very well that according to the conspiracy was held inside the jail, my lord.
No, when they came to know.
Naturally, prior to my release,
Arrest.
prior to my release, my lord. Otherwise, they would not have say all these things, my lord. That's very prior to release. So
only coming to know only looking into the CD lordship.
your lordship, now on the date of release, 5 years should be taken into custody.
Suppose they came to know about.
That they have not stated that but your lordship kindly see the situation.
Yes.
The
We will peruse the case
there
diary.
is story that has been stated in the
If it
FIR.
was known to them earlier that you are also accused in
Yes,
this case,
yes.
then they have a duty to disclose.
That's what. And it's a case of 24. And you'll also kindly see language in the forest that the money was kept in August 24.
Okay, we'll examine it. Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Where is that case?
Yes, sir. Yeah.
Learned counsel for the petitioner. has submitted that the petitioner was
High Court also. Yeah.
earlier arrested in connection with which case?
He was arrested in connection, earlier case, my lord.
In NIA special case number 2/2019, and he was detained in which jail?
Now, presently, I am detained in my Udalguri.
Udalguri district jail. On the date of release, that is on
10/6.
10/6/2025, he was again arrested in connection with
Udalguri PS.
Udalguri PS case number
That is-
Tongla
Tongla.
PS case number 59/2025 under section 5 of the explosive.
I was
Sir.
59/24, man. 59 or 20.
59 of 24.
24.
You have mentioned it as 25.
Sorry, 20.
59 of 24 under section 5 of the Explosive Substance Act, read with section 18 of the Unlawful Activities within bracket Prevention Act 1967. Learned counsel for the petitioner has submitted that as the petitioner was already detained behind the bars, it was incumbent on the prosecution side to inform the petitioner regarding pendency of the second case against him while he was so detained, that is Tangla PS case number 59/25. However, he was not informed, and after he got bail in the earlier case, he was arrested again on the date of his release. Learned counsel for the petitioner has submitted that this is in violation of the guidelines laid down by the apex court in the case of Uday Chand versus Sheikh Mohammed Abdullah, Chief Minister of Jammu and Kashmir, reported in 1983 2 SCC 417. Stop. On the other hand, learned additional public prosecutor has submitted that the case diary may be called for, as without perusing the case diary, the real facts would not be revealed. Stop. Call for the case diary. When?
On 22/7.
Let this case be listed again on 22/7.
Last line, paragraph 5, my lord, it is stated, my lord, there.
Okay, on that day we will examine.
Yeah.
Item 8,
May I please, your lordship. Lordship, regular bail. Accused in jail since 15 December 2024, which is today.
NDPS 22C,
Yes, Lord.
whether investigation is complete, it's going on. Heard, Miss, what is your name? What is your name?
Hopefully it's
Oh, Kids, learned counsel for the petitioner. Also had Miss M. Kakoti, N. Kakoti, learned counsel for the NCB. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the same. When will you produce the case diary? Give a fixed date. 7th of August. Let this case be listed again on 7th of August.
item 9,
Your lordship. For 83 BNSS. Application under 483 BNSS. The accused person in custody for 38 days. Arrested on 8/6/2025.
We'll call for case diary. Heard, Mr. A.K. Bora, learned counsel for the petitioner, also heard Mr. K.K. Das. Call for the case diary.
23rd.
Let this matter be listed on 23rd of July.
item 10,
May I please, your lordship? Section 8 of POCSO is there, my lord.
It's pending investigation.
Nothing wrong.
Whether charge sheet has been,
My knowledge not submitted.
okay. Heard
Please, your lordship.
Mr. C. Chakravarti, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Since offense under POCSO Act is involved in this case, let the notice be issued to respondent number 2 as per the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 5th of August 2025, list accordingly.
Item 11,
Gunai Arvita, also call for the case diary.
My pleasures.
Yes.
The ship total 18 days in custody, your lordship. The list section is 21 clause B and
21?
clause B and 27A of NDPS Act.
Where is the
NDPS
rejection order?
Hmm?
Rejection order.
No, special.
The special, you have not moved bail application before special court.
No.
You don't know, or you have not.
Not filed, your lordship, before the special court.
Why?
Earlier not filed, your lordship.
No, why have you not filed? Why have you rushed to High Court? You could have got bail there, it said. How much is the contraband?
39 grams, your lordship, with
Heroin.
heroin with plastic container.
Heard Mr. A.A.R. Karim, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary.
23rd.
23rd. Let this case be listed on 23rd.
Oblige.
item 12,
May I please, your lordship, my lord? At this statement of case, there may be call for my lord. UAPA is there, my lord.
Heard Mr.
S.H. Sigdal.
S.H. Sigdal, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. All for the case diary. What is the matter?
Not a unlawful prevention act is there, my lord. UAPA is there, my lord.
August first week. Give a date.
August first week, lordship, on
7th. 7th of August.
Oblige.
item 13,
May I please, your lordship?
Yes.
My petition, your lordship, is a business and my lord.
Whether you requested the police as directed by this court or by its earlier order.
Yes, my lord, he sent a mail, my lord.
Thereafter,
Nothing received till now, my lord. No, lordship, I'm paying for 3 weeks, 4 weeks time, lordship, so that he may appear before this appropriate forum, my lord.
where is that mail?
Mail, lordship, put not in this, my lord.
No, when court has directed you to do something,
Yes,
you have to show that you have complied with the court's order.
yes.
You produce that mail.
Day after tomorrow, my lord.
Heard Mr. R. Majumdar, learned counsel for. Heard Mr.
JUNM Laskar.
JUNM Laskar, learned counsel for the petitioner, who submits that in pursuant to the directions of this court by order dated 24/6/2025, the petitioner has sent a mail. To whom you have sent that mail?
Content of compiler.
To the CEN police station seeking extension of time
Right.
for appearing before the investigating officer. However, no response has been received on that mail. Learned counsel for the petitioner seeks some time to produce the copy of that mail before this court. The time is allowed. Let this case be listed again on 17th. Today's 17th of July.
Item 14.
Please, Lordship. In this case, section 6 of the POCSO is inside it. FIR, please tell.
Heard Mr. ATM Hussain, learned counsel for the petitioner. Since offense involving POCSO Act is offense under POCSO Act is involved in this case, hence issue notice to the respondent number 2 as per the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 7th of August 20.
Hardly date may be given.
5th of August.
Next one.
Not this month. 5th of August 2020. You are 18 years old. 30 July 2025. Let also be the case diary be called for. List accordingly.
37.
37.
Item 15.
May please, your lordship. This is pre-arrest bail application, lordship, and POCSO 8 is here, lordship.
And Mr. F. Hussain, learned F. Hawk, learned counsel for the petitioner. Call for the case diary and issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on
30 July.
30 July.
Lordship.
List accordingly.
Deeply obliged. Obliged.
Advice to the special mediation drive. Item 16.
A notification corner sends. Yes.
I am for respondent now.
Who is for the petitioner?
So and more the payment. M more was the payment.
Now unless both parties are present,
Yes, ma'am. Unless.
none has appeared for the petitioner. Mr. S. Bhattakur has appeared for respondent number 1. Is there any hope of amicable settlement?
Probably, but they, is there any?
This matter has been listed as a special drive has been initiated for referring the appropriate matters to mediation under campaign Mediation for the Nation. However, as the petitioner counsel is not present, it is not possible to ascertain whether there is an element of settlement in this case. Therefore, let this matter be listed again
Next one.
in the next week.
So,
In the next week on a date to be fixed by registry.
It is a 12, my lord.
Item 17.
None has appeared for petitioner. None has appeared for any of the parties in this case. List this matter again after 2 weeks.
Item 18.
May I please your lordship? Lordship, I am appearing on behalf of Mr. A. Allen, who is currently in this post. Today, the matter has been fixed for mediation, lordship.
Who is for the,
For the
is there any hope? What is the matter?
child maintenance, ma'am.
Your husband or wife?
Yes, ma'am.
Is there any hope? We are referring it to mediation. You have to submit that. Is there any possibility of heard Miss, what is your name?
F. Farid,
F. Farin appearing for Mr. A. Alam, learned counsel for the petitioner. Also heard Mr. N. Hawk,
Yes, Arbor.
S. R. Borbhia, learned counsel for the respondent. This case is listed today as a special drive for referring the matter to mediation under the campaign Mediation for the Nation. Learned counsel for both the parties. After hearing learned counsel for both the parties, this court is of opinion that there is element of settlement in this case, and it may be referred to mediation. Accordingly, let this case be referred to the Mediation Center of Guwahati High Court. The Secretary of the Mediation Center, Guwahati High Court, shall appoint a mediator in this case from the available panel. Stop. Both the parties shall appear before the mediator, before the Mediation Center of Guwahati High Court. When will you appear? On 5th of August. 5th of August. The report of mediation shall be, report of the mediator shall be laid before this court. Again, on 11th of September. After completion of the process of mediation.
Nice.
Item 19.
Yes, Mr. Sinha.
Yes, my lord.
Who is for the respondent?
Respond,
What is the matter?
matter, there's some obscene word, the accused has, my lord. Alleged to be molested.
Offense is compoundable.
Yes, correct, 294. Compoundable. Obscene word he has spoken, that is the allegation. And he has been punished for fine of rupees 5,000. In default, then 1 month as a simple imprisonment of 1 month. That is the amendment.
This is a revision against the appellate court's order.
Yes, ma'am.
Appellate court has upheld the.
Appeal. That's why, my lord. Only they reduce the fine, my lord. 5,000 to 2,000.
So this may not be a proper case for mediation. Heard Mr. B. Sinha, learned counsel for the revisionists. Also heard Mr. K.K. Das, learned additional public prosecutor. None has appeared for respondent number 1. This is a revision where the petitioner has impugned the appellate court's order whereby the conviction of the petitioner under section 294 of the Indian Penal Code was upheld. This court is of view that this is not a fit case for referring the same to mediation. More so when the informant is not before the court. Stop. Hence, let this case be listed again in its due course by the registry under appropriate column.
20.
So this is the NIX appeal dismissing against the NIX. Checks 1 lakh lordship and sentencing.
Whether the respondent has appeared, he has to appear. Only after that we can decide. Heard Mr. R. Rangme, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. In this case, the respondent number 1 has not yet appeared as notices issued to him are yet to be served. Stop. This case has been listed as a special drive, listed today as a special drive for referring it under the campaign mediation for nation, comma, full stop. However, comma, unless both the parties are before the court, it is not possible to ascertain whether there are elements of settlement in this case. Hence, stop. On perusal of the office note dated 23/2/2024, it appears that notices issued to respondent number 2 has not yet returned. The petitioner is directed to take fresh steps for issuance of notice upon the respondent number 1, not respondent number 2, respondent number 1. Respondent number 1 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 8th of August, returnable on 18th of August, list accordingly.
Getting beer, item 23.
May I please, your lordship? May I plead your lordship? Your lordship, the matter will be taken up after some time. On the last occasion also, your lordship, the matter was adjourned in the similar fashion.
Similar fashion.
Yes, after some time and thereafter it is adjourned.
After how much time? Why? Your senior is not there.
As your lordship places, I am ready.
What
to
is the
take-
matter?
It is it pertains to NDPS case 131 of 2021. And in this case, your lordship, the 2 accused.
Okay,
persons
let
has
him come.
already been granted bail. Similar order.
Who is your senior?
Your lordship, Mr. S.C. here.
Okay, let him come.
Item 24.
My lord, here, my lord, in this case, I am relying on Jihan Kumar. My lord, here section 50 and 51 has not been, of CRPC has not been complied. Page 28, I have annexed the certified copy of notice. Page 28. Only reference of case number has been given. Page 28 and 30.
When were you arrested?
I was arrested on 16/9/23.
16/9/2024. How long you are behind the bar?
As on today, my lord, 633 days. 633 days.
1 year?
Uh,
1 year and how many months?
1 year.
Come back with calculation, proper calculation. We'll take it up after some time. You have to be ready with all facts.
1 year, 10 months.
We'll take it up after next item.
Hello.
Item 25,
May it please your lordship. Lordship, the petitioner is behind the bar for the last 66 days, lordship. FIR is a page 10, lordship. It was closed on 9/1/2025, lordship, and petitioner was arrested on 11/5/2025, lordship. Can I go through the FIR, lordship?
What is the offense?
Lordship, here offense is under 61
Poaching.
two, lordship. But nowhere.
Case diary is there.
Lordship, he is no way involved in the said crime, lordship. Neither any arms has been recovered from him. Only on the basis of the statement of co-accused, he has been arrested, lordship. Here, arms act is also there, lordship.
Yes.
On probability, he has been arrested, lordship.
What is there in the?
Section
Oh, okay. First you read the FIR.
Lordship. With reference to the subject cited above, I have the honor to report that on 9/1/2025, reliable sources revealed that 3 months ago, unknown culprits illegally and illicitly entered Kaziranga National Park via the river road from the Bihapukuri site. These individuals conspired to poach a rhino, sever its horn, and sell it an exorbitant price, thereby obtaining illegal proceeds. However, they failed to execute their malicious plan. Further investigation into the matter has revealed that the group is involved in a larger conspiracy. It has come to light that they have already procured arms and ammunition to carry out their illegal activities. Reliable sources also indicate that they are coordinating with sharpshooters from Manipur and Dimapur to facilitate the poaching of rhino in Kaziranga National Park. In light of the above information, I kindly request you to take necessary legal action against the accused persons and their accomplices to prevent this criminal activity and protect the wildlife of Kaziranga National Park, lordship. It was filed on 9/1 and I was arrested on 11/5, lordship. And no, nothing has been recovered from me, lordship. Only basically on the statement of some co-accused, lordship, I was arrested, lordship. No arms, nothing has been recovered from me, lordship.
No one has been named in the FIR.
Lordship.
Where is your forwarding?
Lordship, forwarding report is at page, lordship, page 14, lordship. Page 14, Annexure B, lordship.
Yes, what is your son?
Kindly peruse page 15, lordship. The next page of the forwarding report, lordship.
Yes.
Kindly see, lordship, one Atabur Ali, lordship. The petitioner has been arrested only on the basis of suspicion, lordship. Firstly, they have robbed the name of one Atabur Ali, lordship. Thereafter, they have cut the name and incorporated the name of the petitioner, lordship. Muhammad Zakir Hussain, lordship.
Yes.
Firstly, I want to state your lordship, I want to focus on the points, what are the sections are there, Lordship. 61(2), that is criminal conspiracy, and 111, that is organized crime. And on behalf of that, Lordship, I want to state here that, Lordship, among one of the co-accused, Lordship, on his, he showed the guns where it is, Lordship. And on 29/5/2025, one live 303 rifle ammunition and one suspected deer enter were recovered from the gang, Lordship. Moreover, if I look into the statement of the accused, Lordship, he has also stated that he was earlier in 2012, he was involved in this case and he was also in jail. Then he also knows Rhino poachers. And all the statements of the accused persons, co-accused persons, they have stated that it came to know that they are habitual offender in these deals, Lordships. And the present petitioner is also arrested by the Forest Department, Lordship. And moreover, if you look into the FIR, Lordship, one thing is important in the middle paragraph, Lordship. They procured sharpshooters from Manipur and Dimapur. These persons are not, this is a gang, organized crime, Lordship. Many people are involved. And it is because of that investigation is going on, Lordship.
May I submit one thing, Lordship? The question arises whether something has been recovered from me, Lordship. It is a matter of 2012, Lordship, now 2025, Lordship.
Okay, heard. Yes.
6 days behind the bar, Lordship.
And his name is named by the other co-accused.
Nothing has been recovered from me, Lordship. Nothing, Lordship. Only on the basis of statement of the co-accused, I was arrested, Lordship.
Heard Mr. P.
He voted.
Bordole, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Zakir Hussain alias Muhammad Zakir Hussain, who has been detained behind the bars since 11/5/2025 within bracket for last
66 days, Lordship.
66
days.
66 days in connection with Jinjia PS case number 66/2025 under section 61(2)/321(9)(3) within bracket 3/11 within bracket 3 of BNS, read with section 25(1) within bracket 1 capital A of Arms Act. The gist of accusation in this case is that on 9/1/2025, one Manojit Malakar had lodged an FIR before the officer in charge of Jinjia police station, inter alia, alleging that it came to the note that informant came to know through reliable sources that about 3 months prior to the lodging of the FIR, some unknown culprits illegally entered Kaziranga National Park via river route, and they have conspired to poach a rhinoceros. However, they failed to execute their plans. It is also alleged that the said group is involved in illegal activities of poaching and have engaged sharpshooters from Manipur and Dimapur to facilitate the poaching of rhinoceros. Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He further submits that the petitioner has not been named in the FIR and no offense has been committed as revealed from the FIR itself. He further submits that the petitioner has been arrested merely on the basis of the statement of the co-accused. He also submits that no arms or ammunition has been recovered from the possession of the present petitioner. Learned counsel for the petitioner further submits that the petitioner has been detained behind the bars for last 66 days, and considering the period of detention, he may be allowed to go on. An additional public prosecutor has produced the case diary of UAPA case number
6 of 25, Lordship.
6 of 2025, and has submitted that the group of which the petitioner is a member is involved in poaching of rhinoceros in the Kaziranga National Park. He also submits that one of the co-accused has led the investigating agency to recovery of one
Live 303 rifle
live 303 rifle and ammunition,
and one suspected deer entered.
and one suspected deer
Entered.
Enter. Stop. He submits that the investigation is still going on, and considering the nature of offense involved in this case, the petitioner may not be allowed to go on bail at this stage. I have you give me the case diary. I have considered the submissions made by learned counsel for both the sides and have perused the case diary. I'll go through the case diary and pass orders today itself.
Lordship.
To part kori rakho chamber of dictation di. Case diary logot.
Item 24.
Oblige, your Lordship.
My lord, today, my lord, 1 year, 9 months, 1 day. Yes.
What is the stage of trial?
Already, Lordship, this evidence of prosecution has been closed.
Closed.
Closed. Now it is fixed for statement of defense. It was last fixed on 11/6/25 for statement of defense.
Okay. What was the recovery?
My lord,
Contraband?
contraband, my lord, 864 gram
Of heroin?
of, you have a tablet. My lord, 6 box suspected drugs.
Yaba tablet contains what? Tramadol.
Tramadol. 864 capsules. Even, my lord, all the seizure.
No, but the trial is likely to be over.
Probably, Lordship, because last date's order is not in the case diary, Lordship. So what happened on 11/6/25?
When your bail was last rejected?
Last rejected, my lord,
By the
page
trial,
44.
by the trial court?
The last, my lord, this Honorable High Court has rejected, page 44, my lord.
We'll call for a report.
Yeah.
If the trial is over by now, or it is likely to go over soon, then let,
Also not both in, my lord, but as per the Supreme Court judgment, my lord, since that it is the duty of the constitutional court, my lord, since we are before the constitutional court. And since there is, because
no, what is your right?
My right is, my lord, the ground of arrest has not been furnished to me, as well as those section, non-compliance of section 50 of CRPC, as well as 51. In Bihan Kumar, there are two parts of.
51 not complied with.
Complied, my lord.
Then it has been complied with. The grounds of arrest has been
That
not
is
been
not
complied.
complied. Page 28, my
Notice
lord,
is there.
it is clear case, my lord. Even one day, my lord, they cannot put me behind the bar, my lord, as per judgment. So, my lord, I think. my submission-
Okay, you are praying for bail on the, where is the notice?
Notice page 28. Notice to the accused, no ground of arrest. That is section 50 of CRPC.
Yes.
Then, my lord, page 30. Then page
I have
30.
gone to the records.
No, my lord, not necessary, my lord, even not for a single day, my lord, doesn't says, my lord. It is,
there,
my lord,
Lordship,
violation of fundamental right, my lord.
But Lordship,
Cannot be, my lord.
in one of the Supreme Court judgment, Lordship, it is Ram Arora something, Lordship, it has been held that the ratio laid down in Pankaj Bansal's case, Lordship, with relation to grounds of.
What is the date of your arrest?
69, my lord.
16?
9/23.
When the Ram Arora Pankaj Bansal
Pankaj Bansal was 4/10/23. 4/10/23. Yes.
Yes,
04/010/23.
that,
So it was before, it cannot be held to be retrospective, Lordship, the effect of Pankaj Bansal.
to that respect, my lord, I have appeared in a case, same submission was made, the coordinate ways and not accepted the, then, my lord, I was in the case. Their arrest was made on, my lord, the arrest was made on 2/9/2023, it Bengal stands. And here 16/9. 2/9/23, accused was arrested, he was allowed to do.
Now, Lordship, we will have to go by the Supreme Court judgment, Lordship.
Yes, I am, by this, my kindly peruse paragraph. I lost
Para?
paragraph 6. Then, my lord, paragraph 16, my lord, 1/6.
Read it.
Paragraph 16, though Mr. Borthakur learned additional public procedure on the basis of decision of the Supreme Court in the case of Ram Kishore Arora Supra, submit that the decisions in Provi POCSO, Pankaj Bansal Supra and Bihan Kumar cannot be given retrospective effect. Yet it is well settled that judicial decisions are presumed to have retrospective application unless mentioned otherwise. So in Bihan Kumar, my lord, there is no specific mention, my lord. Then, my lord, paragraph 18. I am also furnishing Sinha. Here says judgments are always retrospective. Supreme Court says. This judgment.
No, yes, that is a fact, that judgments are always retrospective. But how will you interpret the decision of Ram Kishore Arora, where Supreme Court itself said that
Then, my lord,
Pankaj Bansal is prospective in effect?
paragraph 18, then next line, my lord. Paragraph 18. Though in case of Pankaj Bansal Supra, the word henceforth was used, meaning thereby, from the date of pronouncement of the judgment, the law laid down there. Paragraph 18, 1/8, my lord.
Yes.
Though in the case of Pankaj Bansal Supra, the word henceforth was used, meaning thereby from the date of pronouncement of the judgment of the law laid down therein would be applicable. And on such count, the Honorable Supreme Court has refused to give effect to the same retrospectively in the case of Ram Kishore Arora Supra. And on such count, the submission of Mr. Borthakur has some force. Yet there is no such direction in the case of Bihan Kumar Supra regarding prospective effect of the said decision. That being so, in view of the position of law so laid down in case of Kanish Sinha So judicial decisions are presumed to have retrospective application unless mentioned otherwise. That being so, this court is unable to record concurrence with the submission of Mr. Bhattacharya and additional public. Then I might have the 19. Besides, it appears that the accused is also behind the bar since 2/9/2023. Examination of witness is still going on. Under the here arrest was made on 2/9/23. And in the present case, arrest was made on 16/9/23.
Yes, Mr. Sharma. You want to say anything?
Only that much regarding the compulsory case. Nothing else.
Okay, I'll go through this judgment.
Lodge.
Heard me.
My limited prayer will be also regarding the holding of the status report also, because it is at the fake end of the trial. At least an information also.
No, suppose if he is entitled to get bail, then he will be getting bail at any stage,
Yes, Lodge.
irrespective of stage of the trial.
Lodge.
Heard.
So
What is this?
My lord, this is one, my lord, the Supreme Court says the judgments are always prospective. And another.
No, that is not required. Okay, give it to me.
And another same case, my lord, where arrest was made on 9/8/23, yet bail was granted. Prior to my arrest.
Heard Mr. M.R. Khandekar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let this case be listed for delivery of order on 18th. On 18/7.
I'm deeply.
Item 26 to 32.
And this 6 to 32. So many bail applications.
I'm for 28 now.
28.
I'm for 28, my lord, 23 persons, my lord.
28 dio.
Yes. Now, my lord, sir.
Petitioner number 10, 79 days, and others petitioner
My lord, 81 days and 79 days, my lord.
79 days only.
Petition number, my lord.
No, why these are tagged together?
Same FIR, my lord. Same FIR.
Same FIR, but
Only for large people, my lord, against the police, my lord. There is two groups of people, but in the meantime, the police have randomly arrested from their house 1 kilometer away, 2 kilometers away, my lord. They have taken to custody. Main accused already arrested, my lord. Oh, FIR is page 18 in my.
we are taking up 28 first.
20.
Item number 28. Yes.
Page 18 is the FIR. 30% named in the FIR, my lord.
How many petitioners are there in
Yes,
this?
23.
23 petitions.
23. Our only question is, our case that we are not at all present in the place of occurrence, my lord. We have been arrested from our respective houses, which is far away from the place of occurrence. That's the principle.
FIR is at page?
Page 18, 1A.
Yes, what is the acquisition?
Yeah. Now, basically, it is a matter of fight between two groups. And we are nobody, neither we are related to them, nor might we have any involvement in that. So we are not present, our case, we are not present at all. Main culprit, they failed to arrest main culprits, my lord, only one arrested, two arrested, my lord. Others, they could not, and because of them, my lord, we have been targeted. FIR says what 300 to 350 meters away.
What has happened? Who got injured or?
That is their injury, I think.
This is a police person.
Police person was mine.
Oh, police.
Police personnel got injured, IC and other stuff.
Our case was our involvement is your specific. Yes, they have been injured, that nobody supports it, my lord, because police personnel are there.
The IC of Kharupetia, he got
Please read the FIR.
12 stitches
18, page 18.
Yes.
Respectively begs to state that I, a home guard, so and so, currently posted as driver of government vehicle in so and so state police station. Today at around 8:30 p.m. in charge Silbury Police Outpost, so and so instructed me to take out a government vehicle and to get ready, and also said that there is a commotion at Silbury Sen Mahal. This is the main point of Sen Mahal. That we are not at all involved in the Sen Mahal. Accordingly, I, along with so and so, arrived at Sen Mahal at about 8:45 p.m. by the government vehicle. After crossing about 300 to 350 meters near the Gunship Bridge towards Sen Mahal, below noted accused persons along with around 100 other persons stopped our vehicle and later on vandalized the vehicle by Lati Rod Dao. At that time, IC tried to stop the person by getting off the vehicle. His head was injured by attacking with lathi and also sustained grievous injuries in other parts of his body. When these police personnel tried to save in charge sir, they were also assaulted and they sustained grievous injuries and also tried to snatch away their weapons. At that time, I was sitting in the driving seat and saw SARs being assaulted. One being hit on the head, in charge sir fell down. Instantly, I got off the vehicle and held sir and tried to take him out from there. At that time, I was also hit in the back with lathi, but in spite of assault on all of us, we somehow were able to reach the road. After some time, OC of Dalgaon Police Station, Inspector sir arrived with staff who came with OC sir also sustained injury due to attack by the unlawful assembled person. Instantly, OC sir sent all the injured to Kharupetia Hospital with in charge sir. When OC sir was in hospital, he got to know from Kharupetia Police Station in charge that 12 stitches were applied on the head of so-and-so and sustained fracture and sustained grievous injuries in the joints of leg. Havildar so-and-so sustained injuries on head, chest, hands, legs, and feeling all over the body as informed. Therefore, legal action can be taken. That is very serious allegation. We are not, nobody support this type of accusation. Our case matters whether we are involved or not, we are present or not, whether we have made any role in the matter or not. This is our case, man.
These 23 are out of these 30 named.
Name not because name them because they have given these people maybe known to them, my lord. Now they have been picked up from their house at 1.5 kilometers away, 2 kilometers away, my. We have made a statement, my. We have not been arrested from the place of occurrence.
Yes.
From the respective houses, man.
No, you were arrested later on.
Later on, our arrest is, my lord. Your loss are now, my ultimately, my your loss is 81 days already, my lord. Except 10, just 81 days. The accused number 10 is 79 days.
Accused number 10 is
79 days. And rest accused 81 days. The date of arrest is 26/4/25 and 28/4/20.
yes.
We do not support this type of a matter. That's not a matter. Our case is, one point is
Length of detention.
Length of
detention.
Yes.
Several police persons injured and
Yes.
What is the progress of the investigation?
investigation, one person, item number 20.
No, let us take one by one.
2-3 persons were not, some persons were not arrested, madam. They are still.
Nine point-
No, 28, take item number 28.
28, malad, there are witness, several independent witness, they took name of several persons, malad, I have tell it. And total name, I have, malad, collected total 40 names, and these persons, 23 persons, all names are there, malad. All names are there. Several police persons are injured. I see, malad, FR get, malad, FR is, as per the FR also, malad, 12 stitches in head and one hand broken and injury in ankle also. He was subsequently shifted to Malad. Initially, all were treated at Mongol Civil Hospital. Subsequently, the IC was shifted to GMCH. So, one Malad injury report from the GMCH only regarding that the injury is grievous. That is there, but regarding the injury report, the other persons are not yet Malad, available in the CD Malad, who were treated in the Mongol Civil Hospital.
With a statement of witness, what,
Statement of witnesses are there, Malad. Independent witness, statement of the Malad injured persons.
what is remaining in the investigation?
Malad, few persons here.
Yet to be arrested,
Not to be, yet not yet arrested, Malad. They are.
but they have identified, they have been identified.
Total, I have total, Malad, total I have found 40 persons, Malad. Around 40 persons, Malad, names are there, Malad. And said by different persons. These persons are, Malad, names all taken. And item number one, item is AB, that is
Yes, sir.
Akbar Ali, yes. Item number 27. Item number 27. Other persons are, yes, only materials are there. Only 90 days offense, around 80 days all. But
Okay. Heard,
this
Mr.
item number 27 is, Malak, he is not in the similar for the Malak. He is,
Now we'll take it. Now we are taking up 28.
yes, Malak.
Heard, Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. R. Ali. A.M. Ahmed, learned counsel for the petitioner.
Only one thing I clear, madam. Petition number 13 and 14 already granted bail because of their age. Yes,
Accused number 13 and
13 and 14,
why they were granted bail?
because of the age down mine.
60 years and 66 years.
Yes.
This application under section 483 of BNSS 2023 has been filed by the petitioners, namely 1, 2, 3 up to 23. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 23. Stop. Of the aforesaid petitioners, except petitioner number 10, the other petitioners were arrested on 26/4/2025 and they have completed 81 days under detention. Stop, comma, whereas petitioner number 10 was arrested on 28/4/2025 and have completed 79 days behind the bars. All the above aforesaid accused persons, all the aforesaid petitioners were arrested in connection with Dalgaon PS case number 84/2025 under section 61 within bracket 2/189 within bracket 2/127 within bracket 2/109/121 within bracket 2/324 within bracket 5/317 within bracket 2/118 within bracket 2/3 within bracket 5 of BNS, read with section 3 within bracket 1 of PDPP Act 1984. The gist of accusation in this case is that on 26/4/2025, 1, one Shri Trilochan Deka of Silbari Police Outpost had lodged an FIR naming 30 accused persons in the said FIR, including the present petitioners, inter alia alleging that on the said date at around 8:30 p.m. The informant, along with some other police personnel, went to Silbari Sand Mahal within inverted comma, on getting a report about a commotion at that place. Stop. It is alleged in the affair when this informant along with other police personnel reached at the Sen Mahal around reached at the Sen Mahal, the accused persons named in the affair, along with 100 other persons, stopped their vehicle and vandalized the vehicle, and also assaulted the police personnel. The in charge of Silbari police outpost had sustained grievous injuries along with some other police personnel. All the injured police personnel were shifted to Kharupetia CHC. Stop. Learned senior counsel for the petitioners has submitted that the petitioners are not involved in the offense alleged in the FIR. It is submitted by learned senior counsel that they were arrested from places which were about 1 to 1.5 kilometers away from the place of occurrence of offense. Stop. Learned senior counsel for the petitioner has also submitted that the petitioners except petitioner number 10 have completed 81 days behind the bars, and petitioner number 10 has also completed 79 days behind the bar, and considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor Mr. K.K. Parashar has produced the case diary of Dolgaon PS case number 84/2025, and has submitted that this is a case where law and police personnel were assaulted and injured seriously, and there are sufficient incriminating material in the case diary. Hence, he has opposed the grant of bail to the petitioners. He also submits that some of the co-accused persons are yet to be arrested. And what else? Medical reports have been collected.
Yes.
He also submits that the injury report of the
Injury report of one person is available in the city now. Others
in charge of the Silbari police outpost shows that he sustained grievous injuries on his persons. Stop. I have gone through the case diary which has been produced by learned additional public prosecutor, and have also considered the submissions made by learned counsel for both the sides. Though the offense involved in this case is very serious in nature. However, and though there are incriminating materials against the petitioner in the FIR, in the case diary. However, considering the fact that all the petitioners, considering the period of detention of the petitioners, as well as the progress made in the investigation, this court is of considered opinion that further custodial detention of the petitioners may not be necessary for fair completion of the investigation of Dolgaon PS case number 84/2025. Hence, all the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Dorong Mongoldoy.
You mentioned that petition number 13 and 14 already.
Except all the petitioner
Oh,
except
yes,
13 and
yes.
14.
Out of these,
Yes.
Out
Oh.
of this, I don't know, petition number 13 and 14, they were allowed, by the order 5, 6.
Stop.
5, 6.
It is pertinent to mention here. Goteta, learned senior counsel for the petitioner also submitted that in the meanwhile, petitioner number 13 and 14 have already been released on bail on the ground of their old age. Stop. Tarpisat. This bail application is accordingly disposed of. Send back the case. Now,
26, my lord, my lord.
20,
May I leave, my lord?
yes, 20,
26 also 81 days, my lord.
26.
Item number 26,
Baki. Item number 26.
one person, Julas Ali, 81 days.
Item number 26. Who is the counsel?
No.
Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. Sorry, K. K. Parasha, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Julhas Ali, who has been detained behind the bars since 26/4/2025 in connection with Dolgaon PS case number, same under section same. Stop. Gist of accusation same as Ali. Say আগৰ অৰ্ডাৰটো কপি কৰিব 30,000 with one surety of like amount. 27 এইকেইটা আপনি ল'ব
27 is AB. He is not in same footing, my lord, and his name is there, my lord. 3, 4,
29
29, there are 2 persons, my lord. One is petitioner number 1 is arrested 26/4, 81 days. 2 is arrested on 5/5. He is 71 days.
29
29, petitioner number 1.
29 who is appearing for 29? Heard Mr. What is your name?
Oh, Ansari.
O Ansari, learned counsel for the petitioners. Also Mr. K. K. Parashar. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Noor Muhammad Ali alias Noor Muhammad, who was arrested on 26/4/2025 within bracket for last
Noor Muhammad and my lord.
just a minute, for last 81 days, and Yaqub Ali, who was arrested on 5/5/2025 within brackets 71 days in connection with Baki as item number 28. 30,000 with one surety of like amount. Then 30
Also 26 for 81 days.
30, how many petitioners are there?
One.
Who
Only
is-
one petition.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. K. Parashar. This application has been made under section 483 of BNSS by the petitioner Jamshad Ali alias Jamshed Ali, who has been detained behind the bars since
81 days.
which date?
81 days.
26/4/2025 within bracket 81 days for last 81 days in connection with remaining as it is. 31,
Also 26 for.
There are also 81 days, Lordship. One petitioner, Lordship, Abdul Jalil.
31 also same. Council's name is B. Chaudhary. B. Chaudhary. Petitioner name is Abdul Jalil. Baki Eke.
Highly available.
32.
32 is from 3573 days.
Who is for counsel for?
Yes, sir.
Heard Mr. K. Thakur, learned counsel for the petitioner.
Lordship, in this case, Lordship, I am not named FIR name accused, and I was arrested later on 2/5/2020.
How many days you are behind the
73 days.
K. Thakur as well as K. Parashar. This application under section 483 of BNSS has been filed by the petitioner Abdul Khalek, who has been detained behind the bars since 3/5/2025 within bracket for last 71 days in connection with
73 days.
73 days in connection with Dolgaon PS case number Baki as it is Takibo. Gist Eke Takibo. Only one learned counsel Etabosu Dibo. In addition to other submissions, learned counsel for the petitioner has submitted that petitioner has not been named as an accused in the FIR, and he has been arrested by police merely on the basis of suspicion. Baki as it is Takibo, eto mark koribo. I will have to correct it. Mark koribo. Okay, 30,000 with one security of flag. Now you may go. No, Abhishek. Anticipatory bail, 26.
27, item 27. And his name also taken by the 4 or 5 witness. His name was taken as per injured person also took the name of this person, Akbar Ali. And he is still absconding.
Because he was not present, Lordship, nor his FIR name exists, Lordship, nor he knows the person whose name are in the FIR, Lordship. He was not connected, Lordship, no way. And at that time, Lordship, he was in Kharupetia, Lordship, which is, Lordship, 12 kilometers away from the where the incident occurred, Lordship.
But witness took the name, Akbar Ali's name would be on.
Lordship, he has no connection with the Sand Mahal, Lordship. He is a businessman, Lordship. He used to supply bricks to the hardware stores, Lordship. And that time he is in Kharupetia, Lordship.
Who took his name? You flag mark.
Yes, Akbar Ali.
Heard Mr. What is your name?
SK Hassan Mohammed, Lordship.
SK Hassan Muhammad, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Akbar Ali, who is apprehending his arrest in connection with Dolgaon PS case number 84/2025 under sections Agor case of Adibo. Stop. The gist of accusation in this case, gist copy from other. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the FIR in the offence alleged in the FIR. It is submitted by learned counsel for the petitioner that petitioner has also not been named in the FIR. Stop. He submits that at the time of incident, the petitioner was at Kharupetia, which is about how much?
12 kilometers.
Which is about 12 kilometers away from the place of occurrence of the offence. The petitioner, learned counsel for the petitioner submits that the petitioner is a businessman and is ready to cooperate in the investigation. Anything else?
Lordship,
Stop. On the other hand, learned additional public prosecutor has produced the case diary of Dolgaon PS case number 84/2025 and has submitted that and has opposed the grant of anticipatory bail to him on the ground that there are incriminating materials against the petitioner in the case diary, as some of the witnesses as well as injured persons have named the petitioner as involved in the alleged offense. Yes, what is this, his implication? He was there or he assaulted?
Yes, details not there. One person took the name of 40%, another person was the name of 39%. Both the witness took the name of this Akbar.
In what manner name was taken? What was the role?
So those person he took the name of this person, but what he has done, that specific is not there.
Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary which has been produced by the learned additional public prosecutor. On perusal of the case diary, it appears that though two of the witnesses have named the petitioner as having been involved in the incident of assault along with the other petitioners. However, no specific accusation has been leveled against the petitioner by the said witnesses. Moreover, it also appears that in the meanwhile, most of the accused persons who were arrested have already been granted bail by this court. Stop. Considering the above fact, if the above named petitioner cooperates with the investigating officer, this court is of considered opinion that his custodial interrogation may not be necessary for fair completion of the investigation of Dolgaon PS case number 84/2025. Stop. In view of above discussion, the above named petitioner is hereby directed to appear before the investigating officer of Dolgaon PS case number 84/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2, Abhishek or Pralabha conditions. This bail application is accordingly disposed of. Send back the case diary.
Yes, sir.
Report Chief.
Very pleased also. Here, my note, NDPS, my note, commercial, and I'm sitting my only on the ground of non-furnishing of my note ground of arrest. Arrest was made after Pankaj Bansal, 7/3/2024, madam. As of now, is completed 1 year, 4 months, 7 days. It is also fine. That is, that I have also have certified preliminary arrest memo. Total quantity was 20 kg, 500 grams.
Where is the FIR?
FIR is to find page. Reservation page 18, mile. Reservation supposed to page 18, mile. We start from page 16.
What is your name?
Protima Debabarma.
Where, what is the date of your arrest?
7/3/2024.
How many days you are behind the bars?
1 year, 4 months, 7 days. 492 days.
Where is the notice?
That is page also 49.
Forty-nine is the arrest memo. Notice under 50?
So notice under 50 value is not on that. I'm not enclosed matter. It's a regular arrest memo.
It's in the scan copy also. I've gone through that.
Yes, Mr. Sharma.
That's the position also. Otherwise, also the
Heard.
five PWs have been examined so far, also, out of 8.
5 PWs.
Out of 8.
Heard Mr. F.K.R. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Pratima Debabarma, who has been detained behind the bars since 7/3/2024, within bracket, for last 1 year, 4 months and 7 days in connection with Lumding GRPS case number 18/2024, corresponding to NDPS case number 93/2025 under section 20B2C of NDPS Act, pending before the Court of Learned Special Judge Shankardev Nagar Hojai. The gist of accusation in this case is that on 7/3/2024, one Nandeshwar Das had lodged an FIR before the officer in charge of GRPS Lumding, inter alia, alleging that on that day, after receiving an information through reliable sources that huge quantity of ganja will be transported by some female person in train number 13174 DN within bracket Agartala-Shialda Kanchenjunga Express, a search team was constituted and a search operation was carried out. During checking, during the search operation, one lady was found sleeping on berth number 47 with one airbag and one trolley bag. When the said bags were checked, 20 packets wrapped in brown color plastic tapes suspected to be ganja was found therefrom. On weighing the said contraband, the weight of the same was found to be 20.500 grams. 20 kg 500 grams. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since last 1 year, since more than 1 year, 4 months. He submits that he has moved this bail application mainly on the ground of violation of the constitutional mandate of furnishing the grounds of arrest to the petitioner at the time of her arrest. Learned counsel for this petitioner submits that at the time of arrest, though notice under section 50 of the CRPC was furnished to the petitioner, however, said notice contained no grounds of arrest therein, and only the case number was mentioned. Learned counsel for the petitioner submits that it is in violation of the guidelines of the Apex Court in the case of
Vihan Kumar, my lord,
Vihan-
broadcaster.
Vihan Kumar versus
State of Uttar Pradesh.
Vihan Kumar versus State of Uttar Pradesh. No, State of Haryana.
State of Haryana, my lord.
What is the citation? State of Haryana reported in 2025 SCC Online SC 269, wherein the Apex Court has observed that on grounds of arrest in writing at the time of arrest of an arrestee is the constitutional requirement under Article 22 within bracket 1 of the Constitution of India, and any violation of the said mandate would render the arrest of the petitioner itself illegal, and therefore, under such circumstances, the petitioner is entitled to be released on bail. Stop. On the other hand, learned additional public prosecutor has submitted that in this case, the trial is going on and already 5 prosecution witnesses have been examined. However, he fairly submits that the notice under section 50 of the CRPC, which was served on the petitioner at the time of her arrest on 7/3/2024, does not contain the basic facts which necessitated the arrest of the petitioner in this case. Stop. I have considered the submissions made by learned counsel for both the sides. In this case, though the quantity of contraband seized in this case is of commercial quantity, however, it appears that the constitutional requirement of furnishing the constitutional mandate provided under Article 22 within bracket 1 of the Constitution of India of providing the grounds of arrest to the petitioner in writing was not complied with in this case, and as per the guideline, as per the observation laid down, made by the apex court in the case of Vihan Kumar versus State of Haryana and another within bracket Supra, the petitioner is entitled to get bail on that count only. Stop. Without further discussing the other aspect of this case, this court is of opinion that the petitioner is entitled to get bail mainly on the ground of violation of the constitutional mandate of Article 22(1) of the Constitution of India. Stop. Accordingly, the petitioner, the above named petitioner, is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned, which court?
Sankatam Nagar.
Learned Special Judge
Sankatam Nagar.
Shankardev Nagar Hojai, with following conditions: trial conditions, NDPS conditions. This bail application is accordingly disposed of.
24.
Wait, please, your lordship. 483 application. The accused was arrested on 9/4/23. As of today, the accused is behind the bar for 2 years, 3 months, 6 days. Surseated matter, your lordship. Surseat was filed on
2 years?
2 years, 3 months, 6 days.
Yes.
Surseated matter. Surseat was filed on 27/9/23, and where 8 numbers of witnesses has been listed by the prosecution. Till date, only 4 witnesses has been examined, and the last witness was examined on 24/2/25. And since then, no witnesses has turned up till date. For the last 5 months, no witnesses has turned up in this case.
Yes, what is your submission?
Trial is going on, lordship. Next date of evidence, 7 August, lordship.
7 August, and the last date of evidence was on 10/7/25. No witnesses.
What was the contraband? Which
Contraband was ganja.
Ganja, lord.
How much?
682.2 kg of ganja.
On which, what is your any other submission?
My other submission is that if your lordship peruse Annexure A, page number 9.
Page number?
Page number 9. That is the notice under section 50 of CRPC. There are no grounds of arrest is here. And in page number 10 also, intimation of arrest, no grounds of arrest.
Okay, heard. Mr. J.K. Bhuya, learned counsel for the petitioner. Also heard Ms. N. Kakoti, learned counsel for NCB. This application under section 483 of BNSS has been filed by the petitioner Mohammed Sabir alias Mohammed Shavir, who has been detained behind the bars since 9/4/2023, within bracket, for last 2 years, 3 months, and 6 days, in connection with NDPS case number 151/2023, corresponding to NCB case number 7/2023, under section 20B to C of NDPS Act, which is presently pending before the Court of Learned Special Judge Kamrup Metro. The gist of accusation in this case is that, where is the FIR?
Annexure C, page number 11.
Page number?
Page number 11. It is the search sheet.
that in the instant case, the NCB has filed a complaint before the court of learned special judge Kamrup Metro, inter alia, alleging that on receipt of specific information through reliable sources that the petitioner would be carrying huge quantity of ganja from Bihar, from Tripura to Bihar in truck number NL01AA5344, a search team was constituted and the said truck was intercepted and searched. During search of the truck, aforesaid truck, the petitioner was found in the said truck and 67 packets of ganja concealed in false cavity on the roof of the driver's cabin were also recovered therefrom. On weighing the recovered ganja, it was found that the total weight of the same was 682 kg, 200 grams. Stop. Learned counsel for the petitioner has submitted that in this case, the final complaint was filed by the NCB on 27/9/2023 or 24?
23.
23. And 8 witnesses were enlisted therein. Stop. He submits that out of 8 witnesses, only 4 witnesses have been examined, and the last witness was examined on 24/2/2025, and since last 5 months, no witness has been examined. Learned counsel for the petitioner has submitted that the petitioner is entitled to speedy trial and his prolonged incarceration has, in the instant case, outweighed the embargo of Section 37 of the NDPS Act. Hence, he is entitled to get bail in this case. Learned counsel for the petitioner has also submitted that in the instant case, the constitutional mandate of furnishing the grounds of arrest to the petitioner at the time of his arrest was also not followed. He submits that though notice under Section 50 of the Code of Criminal Procedure was served on the petitioner at the time of his arrest, however, same does not contain the grounds of arrest or Putul, stopper at the requisition demand. Stopper. The line is grounds of arrest. He submits that on the said count also the petitioner is entitled to get bail in this case. Stop. On the other hand, Ms. N. Kakoti, learned counsel for NCB, opposed the grant of bail to the petitioner on the ground that the quantity of ganja seized in this case is of commercial quantity and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. She also submits that out of 8 listed witnesses, 4 are already examined and only 4 witnesses are to be examined, and the next date of the trial is fixed on 7th of August 2025. Anything else? Grounds of arrest?
The bound of arrest to submit judgment lordship.
What judgment?
Amir Khan lordship. In Guwahati High Court lordship.
What it says?
NDPS case lordship.
No, what it says? Relevant paragraph. Which paragraph you are relying? Which
Lordship,
paragraph?
17 lordship.
Please read.
Regarding non-furnishing of grounds of arrest, it is true that the notice issue of the petitioner use section so and so silent regarding communication of the ground of arrest to them at the time of their arrest. However, in this arrest memo is reflected the ground of arrest has been mentioned and communicated to the petitioner at the time of their arrest, which is produced of
In this case, arrest memo was furnished.
arrest memo annexure D lordship.
Page number?
Annexure A lordship notice section is under section 50 CRPC lordship. Their signature is available lordship.
No, the judgment which you are citing, it says that those in section 15 notice, the grounds of arrest was not mentioned, but in the arrest memo, grounds of arrest were mentioned, and therefore there is a compliance of the requirement of furnishing grounds of arrest. But in this case, whether grounds of arrest were mentioned in the arrest memo, only then you can rely on this case.
Also, will notice under section 50 and intimation.
It is not mentioned.
There is no other arrest memo is there.
Learned counsel for the NCB has also relied on. Where is the no arrest memo in this case?
Your lordship only these two.
Where?
Lordship Sabir Mohammed Sabir lordship signature annexure number 1.
No, signature is there, but you have not mentioned the grounds of arrest. Those signatures are there. Learned counsel for the petitioner has. You want to submit anything?
Page number 76 lordship.
Yes. Which para?
Para 22 lordship.
Read, please read.
That as connection made by the accused petitioner by para 6 of present bail petition of the accused petitioner, the arresting authority will arresting the accused petitioner has not informed the ground of arrest to him, and as such the fundamental and constitutional right and under Article 22A of the Constitution of India has been violated. In this regard, it is submitted that the investigation agency had followed all the mandatory provision as per law during search, seizure, and arrest of the accused petitioner in this instant case. The arresting authority intimate the conveyed the ground of arrest to the arrest accused present petitioner in his vernacular language and provide the a memorandum of arrest, section so and so, wherein the arrested had also seen, in addition to that, the intimation letter was also sent to the family of the arrest.
Where is that intimation letter?
The page
number 10, Lordship, and Exam B.
No, page number 10 complies with. But you have a obligation to intimate the grounds of arrest to the accused also. Only family members will not serve.
And in the intimation of arrest, only the seizure part is mentioned.
That gives an indication why you were arrested.
But in the notice under section 15, nothing.
Yes. Yes, you may try further.
It has been followed in
Yes, make your submission.
Lordship also.
My query is, to family members, you have informed the grounds of arrest, but to the accused, you have not informed. And section 50 notice is silent, though in your written objection, you have mentioned that he has signed, but mere signing on a blank notice where grounds of arrest are not mentioned.
Has been communicated, Lordship, Lordship section, notice, Lordship.
Notice under 50 has been, okay. Okay. क्या लिखा? Stop. Learned Counsel for NCB has also cited a ruling of the coordinate bench of this court in the case of Amir Khan and another versus Union of India within bracket bail application number 1448 2025, where in the said case she submits that though sections 50 notice was silent regarding the communication of grounds of arrest to the arrestee, however, the arrest memo reflected the grounds of arrest. Stop. She also submits that in the instant case, the communication sent to the family members of the petitioner contains the grounds of arrest of the petitioner. And in the section 50 notice, the petitioner has also put his signature at the time of his arrest. And therefore, there is a compliance of the mandatory requirement of furnishing of the grounds of arrest. She accordingly opposes the grant of bail to the petitioner. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on the record. In this case, the petitioner has prayed for bail mainly on two counts. First one is the ground of prolonged incarceration. That is, he has been detained behind the bars for last 2 years, 3 months, and 6 days. However, the trial has not yet culminated, and out of 8 listed prosecution witnesses, only 4 witnesses have been examined till date. It is also relevant for that, in spite of the fact that the petitioner is behind the bars for last 5 months, not even a single witness have been examined. On prolonged incarceration, which case you are relying?
Mohammed Muslim and Ravi Prakash and your lordship on judgment.
It is now no longer res integra that prolonged incarceration violates the fundamental rights of the detainee, which were guaranteed to him under Article 21 of the Constitution of India. The Apex Court has observed in several of its rulings that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act. Stop. Moreover, in this case, it appears that apart from prolonged incarceration, the petitioner was not furnished with the grounds of arrest when he was arrested on 9/4/2023. Stop. It appears from record that though the notice under Section 50 was served on the petitioner at the time of his arrest, however, the said notice does not contain basic facts which necessitated the arrest of the petitioner. It only contains the case number and the penal provision involved in this case, which is not the compliance of either the statutory provision contained in Section 50 of the CRPC or the constitutional provision contained in Section 22 within bracket 1 of Article 22 within bracket 1 of the Constitution of India. The Apex Court in the case of Vihan Kumar versus State of Haryana and another reported in 2025 SCC online SC 269 has observed that furnishing grounds of arrest in writing to an arrestee at the time of his arrest is a mandatory requirement under the Constitution of India. Under Article 22 within bracket 1 of the Constitution of India. And non-compliance of this constitutional mandate would render the arrest of an arrestee itself vitiated. And under such circumstances, such an arrestee is entitled to get bail. In the instant case also, there has been violation of the aforesaid constitutional mandate. So, in view of above, in view of the above discussion, the petitioner is entitled to get bail in this case for violation of the constitutional mandate, for violation of the fundamental rights of the petitioner guaranteed under Article 21 and 22 within bracket 1 of the Constitution of India. The above named petitioner is accordingly allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to the satisfaction of learned. Which court?
District and Session Judge.
Learned Session Judge, Kamrup Metro. Session Judge or Special Judge, Kamrup Metro. Special Judge, Kamrup Metro. With following conditions, all NDPS conditions. This bail application is accordingly disposed of.
45.
May I please, Your Lordship? Here, my lord, service completed, my lord, POCSO matter, Amicus may be appointed.
Heard Mr. R.
Borua.
R. Borua, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served
That is reflected in the office note, matter.
Stop. However, no one has appeared for the respondent number 2 in this case. This court therefore intends to appoint one amicus any amicus present. Amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Mr. S. Nawaz, whose name appears in the list of amicus curiae prepared by the registry of this court, is hereby appointed to defend the cause of respondent number 2 in this case. The petitioner shall furnish the copy of bail application along with the annexures to the newly appointed amicus within the course of the day. Today itself.
Yes, today.
Within the course of the day. List this matter when?
Tomorrow, if possible, only 200 days.
He has to go through sometime. 18th. Let this.
Can be on day after tomorrow, Lordship, because already 205 days is behind the bar, Lordship.
Okay, day after tomorrow, 17th.
Take care.
Yes, 46.
May please lost. POCSO matter, my lord. Service.
Service.
My lord.
You have to find out.
My lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor. It appears from the office note that the service report of notice issued to the respondent number 2 has not yet been received. Learned additional public prosecutor is requested to inquire about the fate of the notice issued to the respondent number 2 through the officer in charge of jurisdictional police station and let this court know on the next date fix. When?
Date in the next week or last date, my lord, today, my lord, 18th also.
18th. Let this case be listed again on 18th of July.
Yes.
47.
Regular bail application, my lord. Petitioner is in custody for 50 days now. Case under the Assam Cattle Reservation Act. So initially on 15/5/25, my lord, 22 numbers of cattle were recovered with the police, my lord. Hereafter on 26/5/2011 days hereafter, petitioner number 1 was apprehended by the police while he was transporting 2 cattle on foot. And petitioner number 1 reported to the police that it was the petitioner number 2 who had given him money for transporting the cattle. So as far as the petitioners are concerned, madam, only two cattle were found from petitioner number 1's possession, and he was paid by petitioner number 2. And in our petition, madam, we have specifically averred that these cattle were bought by the petitioner number 2 in paragraph 8, madam. You will also will find that at page 5, madam.
Okay.
Petitioner number 2 had purchased it from Malot Asimuddin Sheikh. The allegation is that we are somehow involved with the earlier recovery of the 22 numbers of cattle which we have been allegedly smuggled. That is the accusation. Now, we have already completed 50 days in custody, so perhaps considering the length of detention also. Yes.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Shah Jahan Talukdar and Amir Hussain, alias Muhammad Amir Hussain, who are detained behind the bars since 27/5/2025 within bracket for last 50 days in connection with Gosaigaon PS case number 65/2025 under section 303 within bracket 2/317 within bracket 2/3 within bracket 5 of BNS read with section 13 within bracket 1 of the Assam Cattle Preservation Act 2021. The gist of accusation in this case is that
Page 18 is the forward number.
on 15/5/2025, one Jadab Bharali had lodged an FIR before the officer in charge of Simul Tapu Police Outpost under Kokrajhar, under Gosaigaon Police Station, inter alia, alleging that on that day at about 5:30 a.m. in the morning, some kettles, about 22 numbers of kettles were found, which were suspected to be smuggled. So, learned counsel for the petitioner has submitted that the petitioners are not involved in the offense alleged in the FIR. He submits that the petitioner number 2 was arrested while he was
Petitioner number 1 was arrested.
Petitioner number 1 was arrested on
26/5.
when he was, where is the,
My lord, page 18, my lord. Page 18, my lord, grounds of arrest number 1. While he was smuggling 2 numbers of cattle on foot.
was smuggling 2 numbers of cattle on foot for the purpose of slaughtering.
Then, my lord, point 3, my lord.
Into sentence to POCSO. No, it is alleged, though it is alleged that the petitioner number 1 was arrested when he was smuggling 2 numbers of cattle on foot. However, actually he was entrusted to take the cattle by petitioner number
2, my lord.
2, who has purchased the
Cattle.
said cattle. Learned counsel for the petitioners has also submitted that both the petitioners are detained behind the bars for about 50 days, for last 50 days, and considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Gosaigaon PS case number 65/2025 and has submitted that there are sufficient incriminating materials against the petitioners in the diary on record and has opposed the grant of bail. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the case diary which has been produced before me by the learned prosecutor. It appears that the investigation in this case has fairly progressed. Further, it also appears that the petitioners been behind the bars for last 50 days, and considering the period of detention and progress of investigation, this court is of considered opinion that further custodial detention of the petitioners may not be required for fair completion of the investigation if they cooperate in the investigation. So, in view of above, both the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned subject learned SDGM within bracket M Gosaigaon with following conditions, number 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
Deeply observed.
Item 48.
Please, your lordship. Lordship, the petitioner is behind the bar for last 60 days. The
60 days lordship, intermediate quantity, the FSL report is still awaited.
60 days.
the COA case was also been released from the
Mr. What is your name?
M. Henry.
M. Hendrik, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Mintu Mishra, alias Minal, who has been detained behind the bars since, which is the date of your arrest, since 16/5/2025, within bracket for last 60 days in connection with Bashishta PS case number 276/2025 under section 21B within /29 of the NDPS Act 1985. On perusal of the records, it appears that the contraband seized in this case is where is the FIR?
Case number 21, my lord.
What is the contraband?
Suspected heroin,
How
35 grams.
how much?
35 grams.
Contraband seized in this case is heroin weighing about 35 grams. Thus, the contraband falls within the contraband is less than commercial quantity and more than small quantity, and thus falls within the category of intermediate quantity, and for which the maximum period of detention under section 487 of BNSS is 60 days. As the petitioner has already been detained behind the bars for last 60 days, he is entitled to get bail in this case. The petitioner is accordingly allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the condition of learned special judge Kamrup,
CGM Kamrup.
learned special judge Kamrup Metro with following conditions. Number 1 and number 2. This bail application is accordingly disposed of.
Item 39.
May I please have a word? The petitioner is behind bar for 62 days. My lord. And so far as the section allegation is concerned, my lord, so far the extortion and cheating is there, my lord. And another section is 35 of Arms Act. So far this section is concerned, my lord, lordship, come to page 17, is the FIR.
Yes.
This is the FIR allegations. The cause of action was in 2021 and 22, my lord. And in fact, so far as the arms that was come, the paragraph, page number 18, kindly come to page number 18, my lord, first para, my lord.
Yes.
কিন্তু দেউতাই ইতিমধ্যে সকলোফালে ধাৰত ফুট গৈছিল আৰু সেয়েহে ভৈৰৱক ফোন কৰি ভৈৰৱ দিছ ইজ দ্য প্ৰেজেণ্ট পিটিচনাৰ সোনকালে ঠিক কৰি নিদিলে কেছ কৰিব বুলি ভাবুকি দিয়ে আৰু সেই ভাবুকিৰে ফাদাৰ অফ দ্য ইনফৰমেণ্ট থ্ৰেটেন দ্য ভৈৰৱ মাইলৰ ভাবুকি দিয়াৰ সেই ভাবুকিৰ পৰিপ্ৰেক্ষিতত যোৱা 2022 চনৰ ডিচেম্বৰ মাহত 4 তাৰিখে ৰাতি 8 মান বজাত ভৈৰৱ কলিতা আৰু এজন অজ্ঞাত ব্যক্তিয়ে বন্দুক দেখুৱাই দেউতাৰ লগতে মোক আৰু মাক প্ৰাণে মৰা ভাবুকি দিয়ে গতিকে প্ৰাণৰ ভয়ত আমি কথাবোৰ কাকো নকওঁ This is in the year 2022, my lord. Out of that statement, my lord, the arms act has come, my lord.
So, what is your submission?
Lordship.
What is your submission?
Lordship, this is the cause of action years back, my lord, 2022. The petitioner is an advocate. As an advocate, the father and the informant took some home loan, my lord, but they failed to pay the return the loan, my lord. That's why he come before to the petitioner to take suggestion. The petitioner suggesting him 2-3 years back, my lord, to take another loan to meet up the earlier loan. This is the part of the petitioner, and in fact, in entire affair, if your lordship go through that the father of the informant.
How much loan was taken?
Lordship, it is not a specific amount. They have stated, my lord.
Okay.
Only stated what amount this father has signed to give the petitioner and other accused persons. Very tactfully, very fairly projected the case, but it was too late. If there is a threat, there's by force taken away money, then why they have sitting over the matter last 2-3 years, my lord? In fact, 2 days, 62 days in custody.
My lord, this is organized crime, my lord. One person introduced the accused person to the father of the informant. Father of the informant is a school teacher, my lord.
111 is also there.
My lord.
111
2.
2, my lord.
Organized crime, my lord, that is.
It is up to 5 years, my lord.
Earlier charge sheet has been laid.
No.
No previous charge sheet against the petitioner.
My lord, fact is that, my lord, the informant's father, my lord, have a loan of in SBI, my lord, 9,11,000 something, and in another bank, 2,67,000. Now the accused petitioner, my lord, assured him that I will request the bank officials and give a loan of 21 lakh. Out of the 21 lakh, my lord, he paid the earlier balance, 9 lakh something and 2,67,000 he paid. And for granting that loan, the accused person took 4 lakhs. Subsequent to that, he convinced the informant's father to take another loan of 14 lakhs. Out of those 14 lakhs, in a single day, he encased 8 lakh, and out of those 8 lakh, the accused person took 7,30,000. Subsequently, again, for another reason, he assured that he will give more money, around 45 lakh, but that time it was sanctioned 16,79,000, and the accused person took around 3,50,000. So, to tell, my lord, whatever the materials in the CD, my lord, I have calculated, my lord, 14,80,000. And in that process, he is not the only person, my lord. Along with the this accused person, my lord, other persons were also there, my lord, who introduced, and the bank officials may be, my lord. And they all took the tune of 14,80,000. But regarding the threatening with showing the arms, my lord, that no arms till seize and all this, my lord. Regarding the arms part, my lord, I have not found any such material regarding the threatening. But petitioner himself, my lord, I am reading 2 lines of this statement, my lord. উদ্ৰ কৰোঁ লেনদেনত মই দেৱানন্দ ৰমণী কলিতা আৰু পিংকু মহন্তই মিলি মুঠ 14 লাখৰ ওপৰত টকা লৈছিলোঁ আৰু বৰুৱাৰ ঘৰত গৈ দম দিয়াটো সত্য।
After lunch.
Yes.
At 2. At 2 will continue.
But at 2, I have just to be spoken to one, but I'll come back.
We'll continue. I'll start dictating. Heard Mr. P. Heard Ms. P. Bora, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Bhairav Jyoti Gogoi, who has been detained behind the bars since 15/5/2025, within bracket for last 62 days in connection with Mathurapur Police Station case number 4/2025 under section 308 within bracket 4 331 within bracket 4 318 within bracket 4 111 within bracket 2 of BNSS, read with section 25 within bracket 1A/35 of the Arms Act. The gist of accusation in this case is that on Nine 3/2025, one Dipankar Borua had lodged an FIR before the officer in charge of Mathurapur Police Station, inter alia, alleging that the petitioner along with two other persons met the father of the informant and asked him and told him that he will help, that they will help the father of the informant to avail loan of rupees 25 lakhs from ICICI Bank so that he can repay the earlier outstanding loan of two outstanding loans of rupees 9,11,123 and 2,67,346. It is alleged that after paying the earlier outstanding loan, the petitioner and other accused persons took an amount of rupees 4 lakhs from the father of the informant. Thereafter, again, a loan of rupees again, the petitioner and his thereafter what happened?
Therefore, another allegation, my lord, for page number 17, my lord, last paragraph.
Okay.
Here-
Yes. It is also alleged in the affair that the petitioner also threatened the informant and his parents by showing a gun, that he will kill them if the matter is disclosed to anyone else. Stop. Learned counsel for the petitioner has submitted that the matter, the allegations made in the FIR against the petitioner relates to the year 2022.
Since 2021.
Since 2021. However, the FIR has been lodged in the year 2025 without showing any justification for the delay. She also submits that no arms or ammunition was seized from the possession of the present petitioner. It is also submitted by learned counsel for the petitioner that the petitioner has been detained behind the bars for last 62 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, Mr. K.K. Parashar, learned additional public prosecutor, has produced the case diary of Mathurapur PS case number 4/2025 and has submitted that there is sufficient materials in the case diary to show that the petitioner has extorted money from the father of the informant on various occasions. He, however, fairly submits that as regards allegations of offense under the Arms Act is concerned, much materials are not available in the case diary, and nothing was seized from the possession of the present petitioner. I have considered the submissions of learned counsel for both the sides, and have also perused the case diary which has been produced before this court by the learned additional public prosecutor. Though there are some material against the petitioner as regards taking money from the father of the informant. However, regarding the allegations of threatening the informant and his family members by showing a gun, except the oral statement of the informant, nothing is on record. No arms or ammunition has been seized from the possession of the present petitioner. Moreover, considering the progress made in the investigation as well as the period of detention already undergone within 62 days, this court is of the opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of investigation of the Mathurapur PS case number 4/2025. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Saraidev, Kumar Sonari. Send back the case diary. This Saraidev with following conditions. Condition number 1 and 2. Above this bail application is accordingly disposed of. Send back the case diary.
I'm okay.
14.
Charge sheet has been. What is the offense?
Malat, offense under section 12 of the POCSO Act, Malat. The affair is at page 12. In fact, Malat, prima facie, there is no such commission of offense, Malat, as stated in the FIR, Malat. Page 12.
Since when you are behind the bars?
Malat, since Malat 17/5/2025, Malat.
You are opposing.
58 days. 58 days. Malat.
You pray before the trial court charge sheet has been submitted. Heard Mr. R. Islam. This is item number?
Item number 40. 40.
heard Mr. R. Islam, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. B. B. Deb, learned counsel for the informant. Stop. Though the case diary was called for, however, learned additional public prosecutor has submitted that in the meanwhile, charge sheet has been laid bearing charge sheet number
108 dated 22/6/25.
Stop. In view of the fact of laying of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail before the said court, regular bail application before the said court, if so advised.
Much.
Item 41.
Thank you, Mr. Lordship. The offense is under section 305B, 317(2), 336(3), 61(2) of the BNA, read with section 21 and 22 of CODPA 2003.
21 and 22 of
CODPA 2003.
what is this CODPA?
Regarding the cigarette.
What is the full form of CODPA? COTPA.
COTPA.
What is it?
This cigarette and others.
Cigarettes and other tobacco products, prohibition and advertisement, regulation of trade and commerce productions of.
Cigarette and other tobacco products, prohibition and regulation of advertisement. Okay.
Trade, commerce production,
Okay.
supply and distribution act 2003. What happened in the forwarding report?
Since when you are behind the bar?
5-6 million. 2000. Forwarding is at pace 15.
45 days.
45 days. What happened, Miller? The petitioner is the authorized representative of Mahakali Enterprise, which is a leaseholder, Miller, of railway. And what happened, Miller?
Where is the FIR?
FIR is at page Miller 12, Annex 2.
Yes.
This is the FIR, Miller.
What is the acquisition?
The allegation against the petitioner is that he is a part of smuggling of foreign cigarettes, Miller.
Okay. What this CODPA prohibits?
Because there are certain
Okay, what is
the punishment is 2 years from the.
what is section 20 of CODPA? CODPA. You have that act with you.
That I don't have.
I know 20 is for, that is the 20 of the CODPA is the punishment for, that is a punishment for failure to give specified warning and nicotine and their
Okay.
content.
Okay, on the packet.
Yes, any person who produces and manufactures cigarettes or tobacco products.
Okay. What is the act called? COTPA.
TPA.
The Cigarettes and Other Tobacco Products Prohibition of Advertisement and Regulation of Trade and Commerce Production, Supply and Distribution Act 2003.
CODPA year is 20?
2003.
2003, okay. So that warning was not given on the packets.
Yes, ma'am. And the maximum punishment is up to 2 years for that. For the first time, first of all.
Okay. Now what is your case?
Here what happened, my lord, I'm an authorized representative of Mahakali Enterprise, which is a leaseholder of railway, my lord. And on 6/3/2025, my lord, one Sri Ajay Kumar has booked 4 packets of old clothes and waiting 280 kgs to transport from Silchar to Shialda. And that was booked, my lord, declaring, my lord, that it's a old clothes, my lord. Thereafter, my lord, the Bongaigaon GRPS got some information, and they, on search, my lord, they have found and recovered cigarettes, my lord.
Okay, then what happened?
And since then, my lord, I'm behind the bar, my lord. My only submission before your lordship is that, my lord. Your lordship, kindly see page 8, my lord. This is the manifest, my lord. I have put my signature here because it was booked under me, my lord, and the signature of the railway authority is also available there, my lord. It is also evident from there.
You are the authorized
representative
of Mahakali.
Mahakali.
How Mahakali Enterprise is involved in this case?
My lord, Mahakali Enterprise is the leaseholder of railway department.
Then how it is related to this case?
Because it is booked under Mahakali Enterprise. My lord.
Okay. The seized substance, okay, where?
Now, your lordship, can you see page 16 of the forwarding report?
Since when you are behind the, how many days you are behind the bars?
5, 6, my lord.
How many days?
5, 6, 39 days.
39 days. Do you need his further custodial detention?
Here, my lord, during the course of investigation, my lord, from his statement, my lord, it is revealed that another one person was there. And my lord, that is from after receiving all the documents, that is, my lord, he was the, my lord, Sardar of this Kuli, my lord, who, my lord, took these things. Otherwise, there's a old cloths. And personal, my lord, now police is searching that person against from whom he received the instruction. Only the thing is that the person, he is from Bihar. Otherwise, my lord, that person's name came out.
The
And
person
police
who
now is
took-
searching. He is from also state from Bihar.
Present petitioner is also from Bihar.
Bihar, my
Yeah, my lord.
Best
I'm the police herder, and I'm here, my lord, for the last 15 years. And also authorized representative of Mahakali Enterprise. You also kindly see page 16, my lord, of the forwarding report.
What you want to show?
My lord, I have disclosed everything before the investigating officers, my lord. You also kindly see the para 10, page 16.
Yes.
May I read, my lord?
Yes.
Investigation of the booking documents revealed that Rambabu Yadav, owner of Mahakali Enterprise, was the leaseholder of rare BP number so-and-so, Kanchanjunga Express of the train. As per booking records, permission was granted to load 4 large bundles of old clothes at Silchar railway station and unload them at Shialda railway station. However, the consignment was subsequently found to contain foreign origin cigarette, falsely declared as clothing material. It is submitted that this misdeclaration constituted a deliberate act of criminal conspiracy and cheating. The leaseholder Rambabu Yadav claims to have had no knowledge of the actual contents. The accused, Sri Rameshwar Singh, Police Sardar of Silchar railway station, was the authorized person responsible for loading and unloading of goods in the said VP number so-and-so. He knowingly loaded the consignment of foreign cigarettes under false representation. During interrogation, the accused disclosed that the contraband cigarettes belongs to Ajay Kumar, a resident of Gaya, Bihar, who has been identified as the prime accused responsible for organizing the transportation and smuggling of the contraband. A copy of the Aadhaar card in the name of Ajay Kumar, along with the relevant booking documents, has been obtained from the railway authorities and taken into custody as part of the investigation. So everything has been recovered also.
Heard, Mr. What is your name?
I
Rafiq, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rama Ishwar Singh, who has been detained behind the bars since 5/6/2025 within bracket for last
He's arrested on 4/6/2025.
forwarding.
4/6/2025 within bracket 39 for last 39 days in connection with Bongaigaon GRPS case number 37/2025 under section 305 within bracket B/317 within bracket 2/336 within bracket 3/61 within bracket 2 of the BNS, read with section 20 within bracket 1/20 within bracket 2 of the cigarette and other tobacco products within bracket prohibition of advertisement and regulation of trade and commerce, production, supply and distribution act 2003 within bracket hereinafter referred to as COTPA Act. The gist of accusation in this case is that on 7/3/2024, one Subroto Das had lodged an FIR before the officer in charge of New Bongaigaon GRPS, inter alia alleging that during regular checking duty and on inter alia alleging that on the basis of an information received through reliable sources, a search was conducted on the rear VP within bracket number 114839 bracket close of Shialda Kanchanjunga Express at New Bongaigaon Railway Station, and during search operation, 2 large packets containing 400 bundles of foreign cigarettes of within bracket Win King size cigarette and another 2 packets containing 250 bundles of foreign cigarettes of namely within inverted comma Gudangaram International were recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner is the authorized representative of Messrs. Ma Kali Enterprise, which has booked the consignment which was later on found to contain foreign cigarettes stock. He submits that you were not aware.
No, me.
He submits that the petitioner was not aware about the contents of the consignment as it was booked, as at the time of booking it was mentioned that the consignment contains bundles of old clothes only. What is your name? Your name is Rameshwar. Rameshwar. He further submits that in the forwarding report of the forwarding report submitted by the investigating officer at the time of forwarding of the present petitioner before the court, it has been clearly indicated that the seized contraband cigarettes belong to one Ajay Kumar of Bihar. This Ajay Kumar has not been arrested.
Not been arrested, my lord, during the course of investigation. He, my lord, stated the name of this Ajay Kumar, my lord. And from him, my lord, may kindly produce his statement also. That he stated that from him, my lord, that is as per his instruction, because of some transaction, he did the same.
Who? The petitioner.
The Ajay Kumar booked the book those
Well,
articles.
statement is there. There is a horizontal flag, my lord.
Stop. Learned counsel for the petitioner has also submitted that petitioner has been detained behind the bars for last 39 days, and considering the period of detention, he may be allowed to go on bail. Where do you reside?
Melody in Silchar Miller. For the last 15
He
years.
also submits that the petitioner is residing, has been the resident of Silchar town for last 15 years. And he will cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Bongaigaon GRPS case number 37/2025 and has opposed the grant of bail on the ground that there are sufficient materials incriminating the present petitioner in this case. He submits that there are materials which indicates that the present petitioner had, on the instruction of the main accused Ajay Kumar, booked. Who booked the
My lord, because here, my lord, from his statement, it is revealed that there is the Ajay Kumar. And police also, during the course, my lord, they have obtained some documents from the railway authority also. Now police is trying to find him out, my lord. In the statement,
What is the last line?
Miller, this Ajay Kumar has booked those articles. That's
But my
why
lord-
this idea is available with the railway department.
Ajay Kumar. The petitioner also
Co-accused, my lord.
assisted in the commission of the crime. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the case diary which has been placed before me. It appears that the contraband, that is the foreign cigarettes involved in this case, have been seized, and the investigation has fairly progressed, though the main accused, namely the one Ajay Kumar, is yet to be arrested. However, it appears that the petitioner has been detained behind the bars for last 39 days, and considering the progress made in the investigation and the period of detention already undergone by the petitioner, this court is of opinion that, considered opinion that if the petitioner cooperates with the in the investigation, his further custodial detention may not be required for fair completion of the investigation of the aforesaid case. For aforesaid reasons, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Bongaigaon, with following conditions. Number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Deeply apologize.
Item 42.
Need please, Your Lordship. Actually, petitioner is behind bars, my lord, in connection with ACB PS plus 33 of 25 under section 61(2)A of PNS, read with section 7A of the Prevention of Corruption Act, my lord. He's been
Since when you are behind the bars?
for last 56 days, my lord, since 25/2005. We had also made a statement in a petition that the wife of the petitioner was expected to give birth to a child on 19th of this month. However, in the meantime, on 7th, she had delivered a child, my lord. So both the mother and the child, they are also in need of the petitioner for his care, my lord.
That is one ground. Any other ground?
My lord, the length of detention is primarily what I'm submitting, my lord. My lord. But the investigation has also progressed, my lord, and
What is the accusation?
my lord, that I have accepted bribe of rupees 10,000.
Accepted bribe.
Of rupees 10. In fact, my lord, the driver of the office had was caught red-handed, my lord. The allegation against me was that I had conspired with him in accepting.
Who driver you have accepted bribe?
That is the allegation, my lord.
Okay, yes.
Lordship, here the case is that the person, the present petitioner is the Lat Mandal, Lordship, and while doing
Evidence is collected.
evidence is collected, but I want to state here, Lordship, it is pending for the report of the chemical examination, as it is a case of trap operation, Lordship. So chemicals need to be examined, Lordship, and to examine the voice of the arrested accused person.
And those have been done.
But it has not been come up, the report.
FSL report is pending.
FSL report is pending,
Okay.
Lordship.
Heard, Mr. What is your name?
I'm D. Kolita.
Mr. D. Kolita, learned counsel for the petitioner. Also heard Mr. K. Das, K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Lokesh Naiding, who has been detained behind the bars since 25/2025, within bracket for last 56 days in connection with ACBPS case number 33/2025 under section 61 within bracket 2 within bracket small a of BNS, read with section 7 within bracket A of Prevention of Corruption Act 1988. The gist of accusation in this case is that on 19/5/2025, one Abul Hussain had lodged an FIR before the Superintendent of Police Directorate of Vigilance and Anti-Corruption, inter alia alleging that the petitioner, who is working as Lat Mandal in the off. Where you are working? Where are you working? In the office of Barkhetri Circle Officer.
Nalbari. Barkhetri Revenue Circle.
Barkhetri.
In the district of Nalbari.
Circle Office, Nalbari has demanded bribe from the first informant, and on 23/4/2025, where is the allegation that you received 10,000 rupees? Which page? Which page?
Actually, he took money with the help of this person, Lordship, the driver.
How much money he took?
10,000. 10,000.
Where is that accusation?
Page 22, madam, it is the last page of the FIR, madam.
22.
20.
Where is that you took 10,000? Read it. Please read that portion.
Last paragraph, madam. Since myself and Hasina were not in support of paying the money to the corrupt blood mandal and the.
No, where is that 10,000? You said that
It is written here, 1,000, but should be 10,000 also.
no, from where you are saying 10,000?
Because in the
statement
flows.
It is not the original FIR.
But original FIR starts at page 25, madam. It is the vernacular.
So you have not translated it properly. In original FIR also 1,000.
1,000.
Kills. Demanded bribe of rupees 24,000. And it is also alleged that the petitioner took that the petitioner
In the 47, it is stated, no.
page 47.
No, Lordship, in under section 47, they given it to the driver, Lordship, where it is stated that subsequent in persons of the bribe demanded by the accused, public servant Lokesh Doi, you have accepted as the part of the bribe amount of rupees 10,000 from the complainant's nephew. Notice given under section 47, Lord. But he was also present in the forwarding report, madam. The forwarding report, actually, in the forwarding report, page 32 is your page, this one, second page. In 32 also. On behalf of Lord, it is stated. On behalf of the accused person.
It is also alleged in the FIR that the petitioner used his driver to accept the bribe, being himself a public servant. Stop. Learned counsel for the petitioner submits that. What is your submission apart from detention?
Grant of detention is the primary contents of matter. Second, praying matter on the medical ground matter is what was delivered.
Learned counsel for the petitioner has submitted that the wife of the present petitioner has delivered a baby in this month only, and his wife and newborn baby requires his presence to look after them. It is also submitted by learned counsel for the petitioner that the petitioner has been detained behind the bars for last 56 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of ACBPS case number 33/2025 and has submitted that the investigation has fairly progressed and there are sufficient incriminating material against the present petitioner. He has opposed the grant of bail to the present petitioner.
Lordship, may kindly just one point, Lordship. It is pending, Lordship, the report of the.
He also submits that the investigation is pending only for receipt of the report of the FSL, report from the forensic laboratory regarding voice
Sample,
as well as
chemical examination.
chemical examination. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of the ACBPS case number 33/2025. Stop. It appears from the case diary that investigation of this case has fairly progressed and it is pending only for receipt of report from forensic laboratory. It also appears that the petitioner has been detained behind the bars for last 56 days. Stop. Considering the progress made in the investigation as well as period of detention undergone by the petitioner, this court is of opinion that further custodial detention of the petitioner may not be necessary for fair completion of the investigation if the petitioner cooperates in the investigation. So accordingly, the petitioner, in view of above, next para, in view of above, the petitioner, above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Nalbari,
PCL judge,
learned Special Judge
Assam, Guwahati.
or Special Judge Assam, Guwahati, with following conditions, number 1 and number 2. This bail application is accordingly disposed of. Send back the case, sir.
Obligation.
Timing item 23.
May I please, Your Lordship? This is a case arising out of NDPS case number 131/2021. Your Lordship, this accused person is arrested on 8/3/2021, and since then he is languishing in the jail. The charge sheet has already been submitted on 1/9/21, and thereafter till today, only 2 witnesses has been examined. And at the time of his arrest, he was in the class 10, pursuing his study. Because of this detention, his career is also getting ruined. In fact, he is not involved in this case. Reason being, he is accompanied with one Safikur Rahman in the vehicle because he was staying in the Manipur, and with a fascination to go to Guwahati, he accompanied him, Safikur Rahman. Safikur Rahman was driving the car. He was just sitting over there, but the car has been detained in the Sonapur, and thereafter some psychotropic substance has been recovered from the vehicle.
What was recovered?
Methamphetamine,
How much?
psychotropic substance is recovered. It is not recovered from the conscious possession of that boy. He was very much innocent. Of course, he is flying in the vehicle. He was never aware. Safikur Rahman being a neighbor, and he was coming to Guwahati with a fascination, being an innocent. He said, I will also go to the Guwahati, and he has accompanied. But unfortunately, the vehicle has been detained in Sonapur, and thereby he has been arrested. And since then, he is languishing in the jail. His father's whereabout is not known to. His mother is single lady, and now she is a poor lady just waiting for his release from the jail.
What is the stage of trial?
Only 2 witnesses have been examined. Because
How many witnesses are?
14, 15 witnesses are there, Lordship. Of course, charge sheet I have already annexed here. Lordship will Safikur Rahman has already been granted bail.
Where is the bail order?
Yes, I am giving your lordship. This is the bail order. ये दे दीजिए. ये वाला दीजिए. ये वाला दे दीजिए. हाँ. Wherein the factual ये तो उसमें दाग लगा हुआ. And your lordship has passed an order. This is also passed by your lordship, wherein long incarceration has been.
In other case, some other.
Is similar person, but in another case, and this one in the same PS case, which is passed by Justice Madam Nandi.
Who is Safikur?
Safikur Rahman is coming in the car. And I am only the accompanying person. I am innocent. I just accompanied to see the Guwahati. And Safikur.
No, Safikur has been granted bail.
Yes, your lord.
Where is that bail order?
That's no, I have given you.
This is not Safikur, this is Tyagarajan.
Tyagarajan. Safikur ka diyan hai na? Yes, I am giving your ones. Safikur. This is
So what is the length of detention?
It's
4 years. 4 years.
now 4 years and
6.
4 months. He was arrested on
Yes.
8/3/21.
Yes, Mr.
8/3/20.
Lordship, here, 10 cases of contraband was seized. And the Lordship may role of the petitioner.
One submission is there, Lordship. The owner of the vehicle has not been arrested. And further, no charge sheet has been filed against the real owner of the vehicle. Though Safikur was driving the vehicle.
How it helps you? How it helps you? Suppose he is not arrested, but whether it helps you?
It is not help matter. I'm dealing with regard to the investigation of the.
No, but that will not help you.
This is the factual matrix of the case which.
Yes, Mr.
Lordship,
Chair.
case 76, we file our objection.
Page number?
76 of our objection. What you got?
No. Yes. Yes.
Role of Krishna Mahapatra Mali in the case was established as under 21. That the seized 10.26 kgs of methamphetamine in crystal form, which is a commercial quantity seized from the port car during extraction also, and which was in conscious possession of Krishna Mahapatra Mali and one other. That the voluntary statement given by Krishna Mahapatra Mali, Jenny made offered money to him for trafficking of the methamphetamine tablet, and he agreed for in this greed of money. As statement given by him, he went to belong at home of Safikur Rahman, and Safikur Rahman sold some packets of methamphetamine tablet loaded in car bearing registration number so and so. Then in the voluntary statement given by Krishna Mahapatra, as per the direction of Jenny Mete, 10 packets of methamphetamine crystal was to be delivered in Guwahati, and Jenny sent a photo of note of ₹10 to him via WhatsApp and directed him that a person in Guwahati would meet him and Safikur Rahman, and so the same note of ₹10 for delivery of consignment of methamphetamine. He accepted that as directed by Jenny Mete. They moved from Lilong for Guwahati to deliver methamphetamine tablet to so-and-so in card number so-and-so at so-and-so. He accepted that it was an illegal work and he should not have involved in this. So the submission of a learned friend, if he is a student, he was not aware. All are not incorrect statement, Lordship.
No, but 4 years he is behind.
No, Lordship, for that also I have replied, Lordship.
evidence is started, Lordship, on 4 occasions. The witnesses were present, but there was no state defense counsel. The case was adjourned. Lordship may note down the dates: 2/9/23, 5/10/23, 2/11/24, 4/1/2024. Lordship, bail application of 3 accused has been rejected by this honorable court. Lordship. These are the order.
There are total 8 accused persons.
We have 3 orders. And Lordship, here, from the conscious position of the present petition, Lordship, contraband was seized. Was the occupant of the car from where the contraband was seized. Here also 50 gram is a minimum quantity. Here also more than 10 cases has been seized. The conscious position of the petitioner and on other.
But how long it will take for,
No, that is Lordship, that is also not in our hand, Lordship.
it is not in your hand, but he will get benefit.
Lordship, every, on each and every date, Lordship, the witnesses are appearing. Lordship has given 4 dates. On 4 dates, Lordship, no counsel was there to cross-examine, so they were sent back, Lordship.
Last he was present on 4/11. 4/11/24.
Yes, Lordship.
Still it is more than,
The ground of arrest is also not there. No ground of arrest has been given. And just given one judgment, your lordship, with regard to the Safiku, which has been passed by this honorable court. There have been, it has very clearly paragraph number 3 to the rest of the thing has been explained, taking the observation of the Honorable Supreme Court with regard to the long incarnation of the accused person.
okay.
From paragraph number 3 to.
Safikur was found along with the present petitioner in the vehicle.
Safikur was there. I am accompanying Safikur. He is already enlarged on date. I am not with other accused person. And at the time of my arrest, I was studying in class 10.
Heard Miss M. Kumari, learned counsel for the petitioner. Also heard Mr. S.C. Kayal, learned standing counsel. NCB,
NCB, Lord.
learned standing counsel NCB. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Krishna Mahapatra Mali, who has been detained behind the bars since 8/3/2021, within bracket for more than 4 years, 4 months, in connection with NDPS case number 131/2021 under section 22C/29 of the NDPS Act 1985, corresponding to NCB crime case number 6/2021, presently pending before the court of, where it is pending?
The session.
Before the special judge Kamrup Metro. Kamrup Metro.
Session date number 2. #65 seal is there, additional session judge number 2, Kamrup in Guwahati. Page number
The
6.
gist of accusation in this case is that on receipt of an information through reliable sources, the NCB officials on 6/3/2021 intercepted one Ford car bearing registration number MN05 A7260 and apprehended two persons. How many persons were there in the car? Two persons from the said car, including the present petitioner. On search of the said car, 10 kg and 276 grams of methamphetamine tablets were recovered therefrom. Stop. After filing of the final complaint by the NCB and after framing of charges, the trial commenced and presently same is pending before the Court of Learned Special Judge, Kamrup Metro. Stop. Learned Counsel for the petitioner has submitted that the petitioner is innocent and has been wrongly implicated in this case. She submits that petitioner, out of curiosity, accompanied Safikur Rahman on his way to Guwahati in his Ford car. However, when the said vehicle reached Sonapur, it was intercepted by NCB officials and contraband was recovered from the said car. She submits that petitioner was unaware about the fact of presence of contraband in the car in which he was traveling. She also submits that the petitioner has been detained behind the bars for last 4 years, 4 months, and till date only 2 prosecution witnesses have been examined. She also submits that the petitioner is seeking bail on the ground of violation of his constitutional rights protected under Article 21 of the Constitution of India on account of his prolonged incarceration. Stop. She has also submitted that the petitioner, the co-accused as well as the co-passenger who was arrested along with the petitioner when the vehicle in which the contraband was found was intercepted, has already been granted bail by a coordinate bench of this court on 22/5/2025 in bail application number 1388/2025. Learned Counsel for the petitioner has also submitted that the petitioner was also not furnished the grounds of arrest at the time when he was arrested in this case. On the aforesaid grounds, she has prayed for allowing the petitioner to go on bail. On the other hand, Mr. S.C. K.R., learned standing counsel for the NCB, has vehemently opposed the grant of bail to the petitioner on the ground that the petitioner was found in conscious possession of methamphetamine tablets, which weighs more than 10 kg and which is of commercial quantity, and therefore he submits that embargo of section 37 of the NDPS Act is applicable to this case. He also submits that the petitioner himself got involved in the offense for greed of money and agreed to transport the methamphetamine tablets from Manipur to Guwahati along with Safiqur Rahman, and sufficient evidence on that account is available on record. He also submits that the trial got delayed also on account of adjournment sought for by the counsel for defense sides on 4 occasions when the witnesses were present before the court. He therefore submits that the benefit of bail on the ground of prolonged incarceration may not be granted to the petitioner, as he himself is the cause for such delay in trial. Stop. I have considered the submissions made by learning. How many witnesses are there, prosecution witnesses? 15. I have considered the submissions made by learned counsel for both the sides and have gone through the records available, gone through the materials available on record, including the scanned copy of the NDPS case number 134 or 130. Just a minute. NDPS case number 131/2021. What is your submission regarding grounds of arrest?
Lordship, I have submitted 3 orders of co-accused there. This honorable court has rejected their application. They were arrested.
Before that, Arveta, learned counsel for the NCB counsel continue koribo. Learned counsel for the NCB has also submitted that 3 of the co-accused namely Ramesh G, Tyagarajan M, and Ganeshan G, who approached this court for bail in this case, were denied the bail by coordinate bench of this court.
The next date is fixed on 20th of August.
26/6, the NCB has also taken the adjournment, your lordship. So it is not only our fault or accused fault for non-appearance or cross-examination of the witness. But
How these Tyagarajan, they are involved in this case?
That is explained in the
Because only 2 accused were found in the vehicle.
so their role were discovered during the investigation.
Okay.
They
What was their role?
activities mentioned in the application. Okay, page 55, role of Ganesh is stated here.
Lastly,
They were receiver of the contraband.
Inte-
They are from Andhra Pradesh.
lastly. And their prayer for bail was rejected by coordinate bench of this court. Stop. I have considered the submissions made by learned counsel for both the sides. In this case, though the petitioner has prayed for bail on many grounds, his main ground is that he has been languishing behind the bars for last more than 4 years, 6 months, and only 2 witnesses have been examined in this case. And only 2 witnesses out of 15 listed prosecution witnesses have been examined in this case. And due to such prolonged incarceration, the fundamental rights of the petitioner guaranteed under Article 21 of the Constitution of India has been violated. On perusal of the records of this case, it appears that adjournments were taken by both sides on different occasions. Stop. The fact remains that for whatsoever reason, the trial court has not been able to examine any further witness beyond 2 only out of total 15 listed prosecution witnesses. The apex court has observed in several of its rulings that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act and 37 of the NDPS Act, and under such circumstances, the petitioner, the accused is entitled to get bail. Stop. In the instant case, only 2 persons were found in the vehicle from which contraband was recovered, namely the petitioner and one Mr. Safikur Rahman. The said Safikur Rahman has already been granted bail by a coordinate bench of this court on 22/5/2025 in bail application number 1388/2025. Stop. This court is of considered opinion that for whatsoever reason, if delay is caused and the petitioner is kept under incarceration for a long period, and there is slow progress in the trial, and there is no hope of early culmination of the trial. Such circumstance would certainly be violative of the fundamental rights of the petitioner guaranteed to him under Article 21 of the Constitution of India. The incarceration of 4 years, 4 months is long enough to consider it as violative of the fundamental rights of the petitioner guaranteed under Article 21 of the Constitution of India. Hence, this court is of considered opinion that the petitioner is entitled to get bail on the ground of prolonged incarceration only. Accordingly, the above named petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to the satisfaction of learned Special Judge Kamrup Metro with following conditions. Conditions Abhishek or Purandoli. This
So 2 COT, one must be government servant also, because he is from Manipur also.
May I please, I would like to submit that, see, that why he's belong to very poor family, no source of income. His mother used to come here and she used to stay in the platform. She may not, railway platform, and then she used to visit me. She is not in a position to give a single penny.
So what is your submission?
My submission is to reduce this 1 lakh of rupees.
How much?
Sir, as
No, how much?
I cannot fix the quantum, but as a mercy.
No, what your submission indicate that he should be allowed to go on PR bond.
Not exactly, your lordship, because if it is.
So let it be there. If
Come to her rescue.
if it becomes cumbersome, you can approach the court for, there is law. Because the co-accused has been released on bail of rupees 2 lakhs. Safikur and you both were found in the same vehicle. And stress. No.
Up to the lordship, your Honor. It's my humble submission.
This bail application is accordingly disposed of.
Out of 2 COT, one must be government servant, because lordship, in many cases, accused are jumping the bail also.
No, which government servant will come forward?
In many cases, lordship, in NDPS cases, lordship is person.
Yes, it is otherwise cumbersome.
Lordship, the reason for asking this lordship.
I have included other conditions. Other conditions will be there. This bail application is accordingly disposed of.
We have filed 5 applications for cancellation of bail on this ground. Because accused are not cooperating, there once bail granted, they flee from the.
No, the recourse is available to both of you
Yes,
under
lordship.
law.
That's why we have come before this honorable court for filing it.
Okay.
Today also we filed 1 application. This is the reason for. Because once they are getting bail, they are not attending the trial.
Then bail will be cancelled and they will never get bail again.
Yes, that's why we have, lordship, in many cases, trial court has issued non-bailable warrant. In spite of.
Yes, if they jump bail,
yes, lordship,
then that would be a sufficient ground to deny them bail.
That's why we are coming for this application.
Okay. No changes.
Item 43.
My please, your lordship. My lord, this is my lord, anticipatory bail application, my lord. The petitioner is a named accused. Affair is page, my lord, 16, my lord.
POCSO.
POCSO, my lord.
POCSO matter.
POCSO. And the alleged victim is, my lord, as per the affair, she is 4 years old, my lord.
What is your case?
My case is, my lord, the petitioner is a teacher, my lord.
Petitioner is a
Petitioner is a teacher,
teacher.
my lord. And
Interim bail granted to the petitioner shall continue till next date.
August, my lord, August.
My lord, the
7th of August.
7th of August.
7th of August.
Item 45, obliged lordship.
Put it to appreciate. I am not an accused, my lord, but pictures of a notice was served upon me. So, my lord, that's why I am ready to appear. Now, I am apprehended that I may be taken into custody. That's why on that day, I submitted with your lordship. Kindly peruse the CD, my lord. If there is any material, my lord, then your lordship will consider it on merit. Otherwise, my lord, I want to go and appear, my lord. I may be given little liberty to protection so that I may appear and record my statement.
I find my objection, lordship. Here, lordship, the contraband is involved 7.47 kgs of methamphetamine tablet. Lordship, page 27, paragraph 6 of my objection, lord.
The CD, I prayed on that day to produce the CD, but I do not know whether CD has been produced or your lordship.
Case diary is there.
Lordship,
Case diary is there.
case diary, we are maintaining a case diary, but today, lordship, I could not obtain.
Okay, we'll bring the case diary, then we'll consider. Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. S.C. K.L., learned standing counsel NCB, who submits that the NCB has filed a written objection against the prayer for anticipatory bail of the petitioner. Stop. However, this court is of considered opinion that the perusal of the case diary would be necessary. Hence, let the case diary be called for. When?
Wednesday.
Next Wednesday. Let this case be listed again on next Wednesday is 23rd.
23rd.
On 23rd of July.
Item 46,
46 charge sheet submitted, lord.
Charge sheet submitted.
Kindly call for a report from your lordship, or whether my name is in charge sheet or not.
No. If your name is there, you will receive the summons. If it is not there, you will not receive the summons. Why you burden the court? Before submission of charge sheet. Now, what is the offense?
ATM dismissal, lordship.
You appear before the trial court if you receive summons. Heard, Mr. What is your name? M. Rahman, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
237/25 dated 30/04/2025.
In view of the fact that charge sheet has been laid in this case, this anticipatory bail application is disposed of with an observation that if the petitioner receives summons from the trial court, he may approach the said court and pray for regular bail before the said court if so advised.
item 47,
47 also cited.
Charge sheet submitted.
Charge sheet submitted.
You have appeared before the. What is the offense?
Trespass and molestation, madam. Allegation
what happened, my lord? The minor child of the petition number one was molested, sexually assaulted by one Bahanta Talukar. And on being
48.
Here, one vehicle, this case is of Sipsagar police station. Here, one Chevrolet vehicle was found abandoned on NH 37, that is in the month of April, 22nd April. Then police seized that vehicle. And then after inquiring that vehicle, police presumed that the vehicle might have been used by the miscreants for transportation of kettles, stolen kettles. But the vehicle was found abandoned in National Highway 37, but no person was there. Thereafter, police lodged this FIR regarding this vehicle, which was found in the month of April. Then, on the basis of that FIR or what, some cattle thieves were arrested from Laujan area on May 16-17. After arresting those cattle thieves, now the present petitioner here is not involved in this FIR logics. But this present petitioner is also having a GI bolero vehicle for carrying goods. So after arresting those cattle thieves, this bolero GI vehicle of the petitioner has been seized by the police on 17th May. Thereafter, the police is searching this present petitioner number one. He is the owner of this vehicle, and petitioner number two assuming him to be the driver of this vehicle. How these petitioners are related?
How your DI is related to this seized vehicle?
And even
And your vehicle has been seized in connection with which case?
maybe regarding that FIR only, police has not even filed the seizure list of this vehicle. Not showing the seizure list also.
What is
And
there in the FIR?
The petitioner FIR is regarding the earlier vehicle, Lordship.
Yes.
FIR is at page 15, 13.
You are not connected with that vehicle. You are
No,
not
no.
connected.
Not connected. But that vehicle is
Yes, Mr. Das, how?
how we are connected, we don't know.
According to this lordship, firstly, that 5 persons were arrested, lordship. Six persons were arrested. And according to that, lordship, one Chevrolet sale car bearing register number so and so from the accused person, Pankaj Tanti, which was used for the cattle theft crime. On dated 8/6/2025, seized one red colored cow and one rope having approximately 10 meters of length, lordship. Then it is stated that the prime accused, the present petitioner's names are there, lordship. And it has been stated
Who made them prime accused?
how they are, it will be, I'm going on that, lordship. It is stated here that, lordship, the accused arrested persons. Firstly, lordship, there are many FIRs are there of cow theft of that area, lordship. This Lone Jan area, lordship. And that the stolen cows are selling to Hanif, this present petitioner, and Anis Rahman. It is their lordship. And hence the alleged accused persons were committing theft from the Demo PS area, lordship, for selling purpose. So they are involved. These persons, other persons, stole the cow and they sold it to the present petitioner's, lordship. And moreover, on that regard, many FIRs has been lodged before the police, lordship, that there has been stolen cows are there.
No, how do you came to know that you are you are being searched for this case only?
Actually, the present petitioner number one's vehicle has been seized. And thereafter, police is searching the owner of the vehicle. And this petitioner number two has
So in which case you are seeking anticipatory bail? In which case you are seeking anticipatory bail?
in this case only.
In this case,
Because
how you came to know that police is searching you?
stated that regarding this case only is searching. But The police has not even filed the seizure list of this vehicle. If those cattle thieves have taken the name of this present petitioner, Lordship, this petitioner used to maybe purchase the cows, but he purchased with valid receipts from the market. So those cows were stolen cows or what, he doesn't know.
The first two lines. Very good.
What is your name? Hanif?
Number one, petitioner number one. So.
What is your vehicle number?
Our vehicle is Bolero pickup FB 1.25T DSIV
What is the registration number?
bearing registration number AS04 BC 1159.
Yes, Mr. Das.
In page
Total-
15 also it is stated that.
Lordship.
In page 15 of the
Yeah.
petition also, Lordship. If I go by this, Lordship, second para. During the course of investigation on so and so, several written complaints received regarding theft of cattle in the Lausanne area. On receiving complaint, inquiry officers have visited the place of occurrence and recorded the statements of complainant. On the basis of the statement, these two persons were also arrested.
No,
Lordship.
no, but the materials has to be in regard to the case before.
Lordship. It is-
Several other cases have been registered. In those cases
Lordship.
implicated, such a general statement would not do.
But
In
it's
this
clearly
case,
stated that-
what is the
It is
evidence?
clearly stated in this area, Lordship, in the objection also, that they were the seller. They were, this person, the other person, this Pankaj.
Where is the evidence?
Lordship.
Who has stated so? Heard Miss, what is your name?
Yeah.
S.E. Ahmed, learned counsel for the petitioners. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Hanif Bora and Anish Rahman. You flagged
Look,
who has
Look,
implicated them.
Lordship.
Anish
If
Rahman.
possible, make kindly fix it to be more or less.
No.
Okay, Lordship.
Let's say
Lord.
Anish Rahman, who are apprehending their arrests in connection with DMO-PS case number 33/2025 under section 303 within bracket 2/341 within of BNS, read with section 192 within bracket 1 of MV Act. What is 192(1)? The gist of MV Act. Section 192. Yeah, motor vehicle. The gist of accusation in this case is that on 7/5/2025, one Ratneshwar, yes,
In vehicle without proper registration. This is regarding that other vehicle, Lordship.
yes,
Vehicle which was found out of that.
yes, yes.
They have even changed the number plate. So this is regarding that vehicle.
It is, yes. California. On 7/5/2025, one Ratneshwar Tai had, ASI of police of Dimo police station had lodged an FIR before the officer in charge of Dimo police station, interiorly alleging that an information was received regarding theft of one cow, received regarding the fact that a vehicle which was used in theft of cow has met with an accident at National Highway number 37 near Dimo. Accordingly, the vehicle bearing registration number AL01 MA 6084 was found in abandoned condition near the restaurant Blue Horizon at Dimo. Stop. During inquiry, it was found that the said vehicle was, it was suspected that said vehicle might have been used for transportation of stolen cattle, and it was also found that a forged number plate was used in the said vehicle. Accordingly, the Dimo PS case number 33/2025 was registered. Learned counsel for the petitioners has submitted that the petitioners are in no way connected with the vehicle which was seized in the said in the Dimo PS case number 33/2025. However, who is the owner of the Bolero vehicle?
Petitioner number 1.
However, the vehicle of one Bolero vehicle bearing registration number
Registration number AS04
AS04
BC
BC
1159.
1159 belonging to the petitioner, petitioner number 1, has been seized by the police of Dimo police station in connection with this case, in connection with Dimo PS case number 33/2025. And no seizure list has been furnished to the petitioner. Now the police is searching for the present petitioners, and they are apprehending that they will be arrested in connection with the aforesaid case, though they are not in any manner connected with the Dimo PS case number 33/2025. Learned counsel for the petitioners has submitted that the petitioners are ready to cooperate in the investigation, and therefore they pray that they may be allowed to go on anticipatory. On the other hand, learned additional public prosecutor has produced the case diary of DMPS case number 33/2025 and has opposed the grant of bail to the petitioners on the ground that during investigation it was revealed that there are several complaints regarding theft of cattle have been lodged in the Dimmu police station, and it was found that the petitioners are indulging in stealing the cattle and purchasing and selling of the stolen cattle.
Moreover, the accused person who stated in the statement that they stole the cattle and this person came and
No, who are the accused?
It is there, Lord. This persons are there.
No, who is the accused person?
Accused person name is Sri Biru Kalandi.
How he is connected with the
He has
seized
stated
vehicle?
that he
How he is connected with the vehicle which was originally seized in the FIR?
because he
There
stated,
has to be some link.
because he has stated that one Bolero vehicle came up.
No, Bolero is nowhere in the picture.
Because her vehicle is the Bolero, Lordship. It is Bolero.
No, you found police found an abandoned vehicle. On the basis of that, FIR was lodged. Now you have gone to a different matter with the
This incident was on 22nd April. FIR was lodged on 7th May regarding this vehicle, earlier vehicle. Then some cattle thieves were arrested on 16th and 17th May, and which were incorporated along with this FIR.
yes, show me where.
Statement, Lord. Can they do?
Who is this Dipankar Praja? Yeah, क्या लिखा last name?
This Hanif name is there, Lord.
No. He has therefore opposed the grant of bail to the present petitioners. I have considered the submissions made by learned counsel for both the sides. Though it appears that some of the witnesses, some of the accused persons who are arrested in this case have stated that the petitioners used to purchase stolen cattle, and also instigated the said accused persons to commit theft of cattle. However, it is not clear from the case diary as to how the petitioners are connected with the accusation made in the FIR, on the basis of which the case number 30, DMPS case number 33/2025 was registered. The investigation of the police has to be in connection with the FIR which has been lodged and regarding which the investigation is being done. If a separate offense is found out during the investigation, if an information regarding a separate offense is revealed during investigation, which is not connected with the offense under investigation in a particular case, comma, a separate FIR has to be registered. In this case, on general statement of the co-accused that the petitioners used to purchase stolen cattle, they cannot be detained in DMOPS case number 33/2025 unless some material indicating their complicity in respect of the allegations made in the said FIR is there. Stop. This court is therefore of the considered opinion that the custodial detention of the present petitioner in DMOPS case number 33/2025 is not justified at this stage. Hence, this anticipatory bail application is disposed of with a direction to both the petitioners to appear before the investigating officer of DMOPS case number 33/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within this within the stipulated period, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. This bail application is accordingly disposed of. Send back the case diary.
49.
Suppose in a case, while investigating a case, a pickpocket, there is a FIR that a theft has been committed in house A. And during investigation, it came to know that in house B, in some other place, there was another theft. And house C also, there was another theft. Can you arrest unless an FIR is lodged, separate FIR is lodged for all the theft in a single FIR? In this case, one cow theft case has been registered on the basis of an abandoned vehicle, and all the suspected persons who are all the persons who are suspected of committing theft are arrested in a single case. That cannot be done.
Item 49.
None has appeared for the petitioner on call. Mr. K.K. Das, London, additional public prosecutor is present. Let this case be listed again on.
Diary sheet is not available.
Again on 30 July. Issue reminder for the case diary.
Board admission item 21.
Yes.
In this case, the watching for FIR lordship. And in this state lordship, the trial is going on lordship. And several chances for evidence, but the victim was not appear lordship. Because the victim made an affidavit lordship. Consenting persons lordship, 376 allegations. Lordship, in this state lordship, I want to lordship file an additional affidavit on the records of the victim affidavit lordship.
Have you taken steps for
Yes, lordship.
for issuance of notice on respondent?
Yes, lordship. Thanks already take this step lordship. And they allow me to file an additional affidavit.
Heard Mr.
M.A. Mondal.
M.A. Mondal, learned counsel for the petitioner, who prays for allowing, what do you want to bring on record?
One affidavit lordship made by the victim. The consenting
To
person.
bring on record the one relevant document
Yes.
which has bearing in this case by filing an additional affidavit. The prayer is allowed. It also appears that the notice issued to, it also appears from office note dated 22/10/2024 that the notice issued to respondent number 2 has been served, but none has appeared. In view of above, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, any amicus present? No. Accordingly, Mr. N. Mahajan, whose name appears in the list of amicus curiae prepared by the registry, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner shall furnish the copy of criminal petition along with annexure to the newly appointed amicus curiae within 2 days from the date of this order. Let this case be listed again for admission hearing when on 6th of August.
Court hearing item 15.
Last week, last. Yes.
Breakfast and accommodation today, Lordship. Say A.M. Bora, Lordship. We have to leave the court.
You are for?
No, I for the informant, respondent number 2. I just like to point out one thing. My lord, this is a criminal petition which is pending since 2013.
2013.
And the
Case diary is there.
My lord.
Criminal petition is for what relief is
No,
sought for?
basically, my lord, the trial was going on. One charge-sheeted witness has been asked by the defense to examine him as a defense witness. Thereafter, a petition has been filed to declare him hostile. That petition was rejected by a particular order by the Court of Session. That order has been subject matter of challenge before this honorable court. So this is the basic case, my lord.
In 2013, so trial is held.
No, the trial has been held. That is why my humble prayer to fix the date, my lord.
Yes.
That is my humble prayer for today.
I asked him it's either 29th or 31st of this month. As per the convenience of the council.
Heard Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Deka, learned counsel for respondent number 2, as well as Mr. K. K. Das, appearing for respondent number 1. Appearing for the state respondent. Stop. Learned counsel for the respondent number, learned counsel for the petitioner has submitted that the senior conducting counsel appearing for the petitioner, namely A. M. Bora, has some personal difficulty today, and therefore he prays for an accommodation. On the other hand, learned counsel for respondent number 2 submits that considering that this matter is an old pending matter of the year 2013, a short date may be fixed. Stop, prayer is allowed. Let this case be listed again on 30. 30 is okay.
I don't, it would be better if it's 35 because 31st is Thursday, the hearing.
On 31st, 7, 2025.
Leave
It may kindly be continued till the next.
Hmm?
There's an interim that may kindly. be
Yes,
till the
the
next day.
interim prayer.
No,
Interim order.
stay. There is a stay.
The order may kindly be continued till the next day.
Okay, the interim order shall continue till next day.
DPO.
Leave